Mic check 1 2. Mic check. Mic check. Mic check 1 2. Mic check.
Nathaniel, are you talking to me?
Nope. I'm just
Okay.
checking. Sorry, just checking the mic here.
All right, then I'm gonna go back. I'm being woodshed, so bye.
Bye.
What'd you say, Mr. Hayden? Oh, you're mute.
mute.
You're the hired gun, I guess.
I am. Underpaid, though, in this instance, I might add. More of a charity matter here.
Hello, Your Honor.
Hello.
You know, I don't even know technologically wise, are they just adding us all in? And do we all, or at least Pat, do you and I stay on the whole time?
No,
So
the
we're-
only time I think anybody is on is when we're testifying, unless they specifically ask us to come on. But it'll just be, at least the ones this morning, it was just the presiding judge and the two attorneys, and then whatever screen sharing there was for documents from time to time, and then whatever witness there was.
So, and I forgot to ask, does that mean we need to stay in these rooms for the whole time in case we get called back? Okay.
That was the
There's a
question I got.
situation where you're released. Like when in every trial, when the witness is finished, the judge usually asks, is this witness excused? Meaning I'm not going to call him for rebuttal. And
Right.
if you're excused, then you're done. If you're not excused, you kind of have to hang around,
Got it. Okay.
subject to recall.
Well, I was thinking the instructions said we needed to go to the student lab. I mean, that was, I don't know, obviously for the preliminary rounds, hang around, not leave the premises.
I think the judge can issue a bench warrant to come find you.
Wow.
Okay, who in the building is the enforcer then?
Little.
Yeah,
That was what I was thinking.
Okay.
Yeah, no, check her out here, get going with everything.
changing this so I have America behind me.
Oh, I don't have either.
Everyone, there are a bunch of people in a waiting room and I'm about to let them all in. So,
You want us to go off camera?
yeah, feel free to hang out. You can turn off your camera until you're called. And, but I just want to let you know that I'm about to flood the room. Here we go.
You can, if you are good to go, turn your camera on.
Hello.
Hello, everyone. I'm trying to make sure I've got everyone in the room who needs to be here. So y'all be patient with me for a second. Okay. So I think everyone's in. I'm going to check you all in and get us started here quickly. I'm Judge Mitchell. I'm going to be the presiding judge for the round. And so I think what we're going to do is, if you are not an attorney speaking or a witness who is currently called, if you will turn off your video, and I will hide all the non-video people so that what we'll see on our screen is just the lawyers who are speaking and the witnesses who are speaking and me. So let's test that out. Perfect. Okay. We are just shy of 3 o'clock, but I'm happy to start us early. It looks like everyone is, let me make sure I've got all my judges here. Right, I've got Mark and Jordan, Mayfield, Marilyn, Lynn. Okay, all my judges are here and I see 2 attorneys here. Good. All right, good afternoon. I am Judge Mitchell and I'm here to preside over your final round. Welcome. Feel free to message me if something happens with technology and you're having trouble. Y'all are pros at this by now. I know this is the final round, so I'm not going to give you any more instructions. Are you all ready to proceed?
Yes, Your Honor, the plaintiff is ready to proceed.
This is the defense.
Okay, wonderful. Well, are there any housekeeping matters that we need to take up before we begin?
Yes, Your Honor. May plaintiff make appearances for the court?
Yes.
Good afternoon, Your Honor. My name is Zoe Appler, and I'm joined by my co-counsel, Miss Valerie Letko. Today, we represent the plaintiff, Miss Jordan Gilmore.
Good afternoon, Your Honor.
Apologies, Your Honor. I do believe you're muted.
Someone live in the room is talking to me. Sorry, you guys, I muted myself. All right. Proceed, you guys, I'm listening.
Appearances from the defense.
Yes.
Good afternoon, Your Honor. My name is Jenna Forster. I'm here today with my co-counsel, Cheyenne Smith. And together we represent the defendant in today's case, and that is Chimes Department Store.
All right. Welcome, everyone. Are there any additional housekeeping matters we need to take up before we get started?
Yes, Your Honor. The plaintiff just has a few pretrial matters to attend to. Just some questions for Your Honor.
Okay, proceed.
Now, when laying the foundation to admit an exhibit into evidence, do you want the witnesses to have the exhibits available to refer to, or would you prefer that we put them up via share screen constructively outside the presence of the jury?
Constructively is fine. Yeah.
And for objections, Your Honor, would you like us to ask to be heard outside the presence of the jury, or are we always constructively outside the presence?
Let's just assume we are constructively outside the presence. That'll make it go a little more quickly.
Understood, Your Honor. And finally, we'd like to inform the court that the parties have stipulated to the admission of several exhibits in today's trial. Would Your Honor like a list of those exhibits?
Yes, and I'll make a note of those. Go ahead.
We've stipulated and admitted exhibits 1 through 7, along with exhibits 16 through 35.
All right, great.
And Your Honor, with that, we have no further housekeeping matters from the plaintiff.
There's just one housekeeping matter from the defense, if that's all right, Your Honor.
Proceed.
And that is all of those exhibits that we've agreed to pre-admit or any other documents that we admit during the trial, should we ask for permission to share them on our screens? Should we ask to publish to the jury before we share? Can we just go ahead and do that?
Once an exhibit is admitted, you may feel free to use that with the jury. You don't have to ask me each time.
Excellent. That's all from us. There are some substantive matters, but we're happy to let the plaintiff go first.
Okay, let's proceed on with those then.
Plaintiff has no substantive matters, Your Honor.
Okay, let me hear from the defendant.
Yes, Your Honor. We wanted to let you know that also when we met and conferred with the plaintiff before today's trial, we were able to stipulate to the height of the loading dock at issue in today's case. This is a slip and fall case in which the plaintiff fell off of a loading dock in the defendant's workplace. And so we've stipulated that the height of that dock is 34 inches.
Okay.
We also at this time would ask Your Honor to take judicial notice of a particular provision of law that was in effect in Waco at the time of the accident in January 2019. Happy to share that provision on my screen at this time.
Okay. All right, is there any objection to the court taking judicial notice of this?
None, Your Honor.
Okay, the court will do so. What's next?
Lastly, Your Honor, the defense would move to exclude a particular piece of evidence in today's case that Chimes added a light switch in their store after the accident that controlled an outdoor light. This would be inadmissible under Federal Rule 407 as a subsequent remedial measure. It's barred by that rule and it's not covered by any of the exceptions today. We'd move to exclude it.
Okay, response?
Your Honor, we would move to include this particular line of testimony as it does fall under one of those exceptions, feasibility, whether or not it was feasible for the defendant to install this particular light switch in their store. Now, we'll hear evidence throughout today's trial today that it was in fact easy and that the defendant actively chose not to do so until after this accident. That goes to feasibility, and that is an exception under 407.
Response?
Yes, Your Honor. Rule 407 says that the court may admit the evidence for another purpose, for instance, if disputed, proving ownership, control, or feasibility of precautionary measures. Defendant does not dispute the feasibility of that measure today, and so it's not admissible.
Any final word on this?
Your Honor, we stand by our previous argument.
Okay, all right. I am going to exclude that. Anything further?
Nothing further from the defense.
All right. Are you all prepared to proceed with opening statements?
The plaintiff is ready to proceed, Your Honor.
All right. The court will recognize the plaintiff for purposes of opening statements. Proceed.
May it please the court. Counsel, members of the jury. Carelessness creates consequences. When people are careless, when they go through life with a disregard for safety, well, they can hurt others. When a driver gets behind the wheel of a car after having a few drinks, that driver's being careless, putting the safety of others in danger. But members of the jury, you're going to hear today that we're not here because of a careless driver, not even a careless person, in fact. You'll learn that we're here today because of a careless company. Today, you'll learn that the defendant, Chimes Department Store Incorporated, chose to be careless. You'll learn that Chimes chose their image over their employees, their profits over their people. You'll hear that this company chose to brush problems under the rug, chose to ignore glaring safety issues. And you'll learn that one of their most dedicated veteran employees, Miss Jordan Gilmore, suffered the consequences of their carelessness. Now, you'll learn today that the law has its own word for carelessness, and that's called negligence. Good afternoon, members of the jury. My name is Zoe Appler, and I'm joined by my co-counsel today, Miss Valerie Letko. And we're here on behalf of the plaintiff, Miss Jordan Gilmore. Now, we're here today because Miss Gilmore suffered an injury while working at Chimes Department Store. And as a result, she's brought this case of negligence against the defendant. You'll learn today that on January 23rd of 2019, Miss Gilmore was injured because of the defendant's negligence. We have to prove that to you today by a preponderance of the evidence. Now, to do that, I want to take you back to 2009 here in the great state of Texas, right here in Waco, in fact. You'll learn today that that's when Miss Gilmore proudly began her job as an employee of Chimes Department Store. Today, you're going to get to meet Miss Gilmore. She's going to take the stand and tell you how she dedicated 10 years of her life working hard as a cashier for the defendant, how she loved her job, tried to follow the rules, give her best, day in, day out. Now, you'll also learn that in 2015, the defendant enacted a new policy, and this was a smoke break policy. Now, members of the jury, we all have our vices, and Miss Gilmore will tell you that hers was cigarettes. She was a heavy cigarette smoker, and part of her daily routine at work was taking a smoke break about once a day. Now, she'll tell you that the defendant's new policy said that all smoke breaks had to be taken out back, behind the store, near the back door. You'll learn that this policy was put in place to protect the defendant's image, that they didn't want their customers to see their employees smoking or to walk through a cloud of cigarette smoke on their way in. A request that might seem reasonable to the average employer. But today you're going to learn what smoking out back really meant for employees. You'll hear about the dangerous conditions that the defendant subjected their employees to. You'll see that any employees who wanted a smoke break, including Miss Gilmore, had to stand on this exposed concrete platform behind the store, right next to the dumpster. A platform that was falling apart, a platform without a handrail, without adequate lighting nearby, a platform with chunks missing from it, pieces of metal sticking out of it. You'll learn that this was the designated smoking area the defendants chose for their employees. You're going to learn that the defendant knew that this area was dangerous. You'll hear that it violated building codes, government regulations, and that their management never bothered to inspect it for any safety concerns or hazards. You'll learn they were careless. And you'll learn exactly what that carelessness meant for employees like Ms. Gilmore. You're going to hear about January 23rd of 2019. It's a cold, windy night here in Waco. We all know by 7 p.m. this time of year, the sun's gone. Darkness has set in. Around that time, Ms. Gilmore and her coworker head outside to take a smoke break. And they go out back, just like they're required to do. They open that back door and are met with a rush of cold air, a gust of wind. Ms. Gilmore ascends those stairs to the ground, choosing to withstand the cold instead of smoking in the doorway so that the smell of her cigarette won't sneak inside. But the stairs and platform that you'll hear she could navigate so easily during the day are much tougher in the darkness, because you'll learn there was no lighting. No street lamps, no exterior lights, only a sliver of light coming through the small opening in that door. So Miss Gilmore quickly smokes her cigarette, heads back inside, and as she climbs the stairs to that platform with so little light, no railing to grab onto, she slips. No guardrail to catch her, she falls to the ground and lands on her right leg, damaging her right knee. Miss Gilmore will tell you that after that fall, she had to have her knee replaced. All because the defendant chose not to prioritize the safety of their employees. In fact, you're not only going to hear from Miss Gilmore today, you're also going to hear testimony from an expert witness, Mr. Kelly Daines. You're going to meet Mr. Daines today, and he'll tell you that he's a mechanical engineer. Members of the jury, Mr. Daines' testimony will make it clear to you today that Chimes department store violated numerous federal guidelines, particularly those that govern handrails, that govern lighting, that govern doors. And the evidence will show you that this area wasn't safe, and that the defendant knew it wasn't safe. They knew this platform was dangerous. They knew that those stairs weren't safe. They knew that that lighting was inadequate. And you'll hear they didn't do anything to fix it. They couldn't be bothered to make this area safe. This area used not only by smokers, but by any employee instructed to take out the garbage, any employee loading and unloading deliveries. The defendant didn't just put Miss Gilmore's safety in danger. They put all their employees at risk. The evidence will show that the defendant chose carelessness, chose ignorance over their employees and over safety. And that Miss Gilmore, she suffered the consequences of their carelessness. Now, at the end of today's trial, I'm going to come before you again, and I'm going to ask you to look at the facts, to look at the evidence, and to apply the law, and find the only verdict supported by the truth. I'll ask you to hold the defendant liable. Thank you.
Thank you, counsel. The court will recognize defense counsel for opening statement.
Thank you, Your Honor. The steps were safe if the employees were safe. Today, you're going to hear about Chimes department store, located right here in Waco. You will hear about the loading dock located at the back of that store. And it's true, you will hear that the plaintiff, Miss Jordan Gilmore, got hurt on that dock. But folks, what the evidence will show is that that loading dock, those steps, they weren't dangerous as long as you were being careful. The evidence will show the steps were safe if the employees were safe. You're going to hear a lot about Chimes department store today. In fact, you'll meet its owner, and that's Reese Geller. Ms. Geller is going to take the stand and tell you all about that store, how it's a family business, how she is actually the third generation of Gellers to own that store. Her grandparents started it decades ago. Her parents took over. And 10 years ago, she became the Geller in charge. And she'll tell you that in 2005, business was good. Chimes wanted to move to a new, bigger location, and so they did just that. They moved to their location over on Bosque Avenue, downtown. You're going to hear about that location today. You'll hear that when they moved in, it had just a front entrance and a back entrance. Ms. Geller will tell you, well, Chimes needed a loading dock. So they wrote a request to their landlord. They had their landlord pave a pathway out to that back exit and take down a railing. And you will hear that after that, for the next 14 years, Chimes used that area as a loading dock. You're going to hear that this very same loading dock, that the plaintiff herself, Ms. Gilmore, used it for 10 years. On every single shift that she worked, she never once fell. Until January 23rd, 2019. You'll hear what was different that day. Ms. Gilmore heads out onto the landing, walks down the stairs in order to take a smoke break. She smokes her cigarette. She throws the butt in the dumpster. She goes to walk back up those stairs, stairs she has walked literally thousands of times before. She's walking up those stairs, and what she sees is this. Now, she's on the other side of this photo. But what she sees is the door extending into the walkway, blocking her path. Now, she knows that there's a coworker of hers on the other side of that door. And at this point, Ms. Gilmore has a couple choices. She can choose to just push that door closed or ask her coworker to do it. She can choose to pull that door open. You'll hear it opens all the way so that it's flush against the wall. Or she can choose to try to scoot around the edge of that door in a space that you will hear is just 12 inches between that door and the edge of that dock. Of those choices she has, she picks that last one. She tries to scoot around that door. She takes a step in the dark, and she misses. She falls. And she gets hurt. This is a negligence case. The plaintiff has chosen to bring a negligence claim against Ms. Gilmore's former employer, Chimes Department Store. What that means is that it is the plaintiff who has got to prove a few things to you today. They have to prove to you that there was an unreasonable risk of harm on those steps. They have to prove to you that Chimes knew or should have known about that risk. And they have to prove to you that Chimes didn't use ordinary care to protect its employees. Folks, they're not going to be able to do that today, because the evidence will show you there was nothing about those stairs that was particularly dangerous to begin with. Now, Ms. Geller is going to come before you. She will tell you about that store. She will tell you about that loading dock. And she's going to tell you, you can't have a department store without a loading dock. She'll tell you, you can't have a loading dock that has a railing around it. Just doesn't make sense. That's why they took that railing out. But she'll tell you that in 14 years of using that dock, just like they did, the exact same way, over those 14 years, those thousands of employee trips out there, there were just two times that anyone ever fell down those stairs. She'll tell you they had no reason to believe that that staircase was any more dangerous than any other set of stairs. Folks, you won't just hear that from Ms. Geller, you will hear it from an expert in this field, an OSHA inspector. Now, OSHA, that is the federal agency that's in charge of workplace safety. Now, this inspector who you will meet, Perry Hayden is his name, and you'll hear he doesn't have a stake in this case. He's not getting paid. He might not even have particularly wanted to be here, but we asked him to be because he's the person who inspected the defendant's store. And he'll tell you when he did that inspection at Chimes, he didn't come up with a single problem. He wrote them a clean bill of health because that store was safe. I want to be clear about what I mean when I say the steps were safe if the employees were safe. We are not asking for those employees to be perfect. We're not asking for anyone to be perfect. What we're asking for is for everyone to take responsibility for their own actions, something every person on this earth has to do. If you act carelessly and you get hurt, you have to take responsibility for that. And today the facts will demand that we do just that. The facts will demand that we look at Ms. Gilmore's actions herself. Because you will hear about when she walked up those steps that dark night in January. You will hear about when she came across that door blocking her walkway. You'll hear about the choices she had and the choice she made. You'll hear she wasn't safe. And so at the end of this trial, I will come before you again. I'll remind you of all of that evidence. I'll remind you the steps were safe if the employees were safe. And I'll ask you to find Chimes not liable. Thank you.
All right, who will be plaintiff's first witness?
Your Honor, the plaintiff calls Miss Jordan Gilmore to the stand.
All right, good afternoon, Miss Gilmore. Will you please raise your right hand to be sworn? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, counsel, you may proceed.
Good afternoon, Miss Gilmore. Can you hear and see me okay?
I can, thank you.
Great. Would you please introduce yourself to the members of the jury?
I'm Gordon Gilmore.
Where are you from, Miss Gilmore?
I'm born and raised right here in Waco.
Do you still live here?
I do.
Do you work here?
No, not since the accident.
We'll get to the accident in a moment, but where did you work before that?
I work for Chimes Department Store here in Waco.
What is Chimes?
Yeah, it's a department store. It's a kind of the local place to go, just a department store in Waco.
What was your position there?
Mostly cashier.
And how long did you work for Chimes?
Just about 10 years.
So why do you no longer work at Chimes?
After the accident, I had to have my knee replaced. And by the time I was able to begin to come back to work, they just didn't have a place for me. They'd let me go. They'd fired me and then couldn't seem to find a place for me anymore.
Now, when did this accident you referred to occur?
January 23rd, 2019.
Okay. Now, I want to talk to you about that day, Miss Gilmore. Do you remember that day fairly well?
Oh my goodness, yes. It's a nightmare day for me.
When were you working that day?
I went to work at noon and I was scheduled to work until closing, which is at 8. And it always takes us some time after that, but that was the schedule.
During the course of your shift, Miss Gilmore, did you take any breaks?
I did, and it was about 7 o'clock when I took my last break, and it was a smoke break to go outside and take my smoke break.
Where did you take this smoke break?
Out in back on the dock. That's where we were told we had to go when we wanted our smoke break.
You said you were told to go there.
Mm-hmm.
Who told you to do that?
I mean, management, we all knew we were not supposed to smoke in front of the store, that the only place to do that was out back.
How did management communicate this requirement to you?
In a number of ways, and there was a memo at some point, but we all knew. I mean, every day we knew where we needed to go.
I'm publishing what's been pre-admitted as Exhibit 1. Can you see that okay, Ms. Gilmore?
Oh, can you blow it up for me just a little bit? Yes, yes.
There we are. And can you tell us what we're looking at here?
That is the memo that we all got that told us, loud and clear, no smoking in the front.
And what date was this memo sent to you?
July 1, 2015.
Now, my co-counsel has blown up some language from this memo. Can you tell us what that says?
That's where it's telling us we cannot smoke out front. As you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. This is the only place you should take smoke breaks on the premises.
Retrieving the exhibit. Now, Ms. Gilmore, did you ever take a smoke break out front?
Oh, no, ma'am.
Why not?
Well, I'm a rule follower and they told me not to, but I also understood. I really enjoyed working for Chimes. I wanted to be a good employee. I wanted people to have good impressions. I know smoking is a nasty habit, and I didn't want our customers to walk in the front door and have to walk through smoke and cigarette butts or any of those things. So I understood that we needed to go to the back so that our customers did not see us smoking.
Now, Ms. Gilmore, can you describe for the members of the jury what the area you had to smoke in looked like?
It was this little loading dock on the back. It was dark. In January, it gets dark at about 5:30, 6 o'clock. So by the time I went out there, it was really dark. There is a light, but that light's never on. We've complained about that, but they always said, well, we don't have the light switch. The light switch is at the Tractor Supply store next door. Sorry, you're out of luck. And that night was, oh my goodness, bitterly cold. It was windy. It was just pitch dark. It was a miserable night. And, but if you're a smoker and you're addicted, when you need to smoke, you need to smoke.
All right, Ms. Gilmore, I want to take that piece by piece. I'm publishing what's been pre-admitted as Exhibit 19.
Okay.
Can you see that okay, Ms. Gilmore?
Yes.
Tell us what we're looking at.
That's the loading dock. That's the back door to Chimes. And you'll see that if you're looking at those doors, we come out there, that door on the left, that's the one that opens up. You come out, you go around, you go down the stairs, the dumpster's there. I came out with my coworker, Riley. I walked down the stairs so that I was smoking where I had been told to smoke is not in the doorway with smoke blowing back in. And it was cold, but I did, what I knew they wanted me to do. So I walked down those stairs to smoke.
All right, Ms. Gilmore, I want to walk through step by step what happened that night. Now, you said someone went outside with you. Who was that?
Riley Huntsberger. She's my coworker.
And when the two of you got outside, were there any lights on?
No, ma'am. Pitch dark. And there wasn't even a moon. I mean, it was a cloudy, overcast, windy, miserable winter night.
I'm publishing what's been pre-admitted as Exhibit 2. Now, you mentioned a light on the wall, Ms. Gilmore. Is that the light that's circled in this photo?
Yes, ma'am.
You said that light wasn't on, right?
No, ma'am.
Had you ever seen this light on before?
Not that I recall ever.
Were you, as an employee, able to turn it on or off?
No, ma'am.
You said that the switch was in the Tractor Supply store next door, correct?
Yes.
Did you ever complain about that lack of a light switch to your management team?
Yes, we did.
How did they respond to your complaints?
just to explain that we didn't have a switch in our store, that the switch was at the Tractor Supply place next door, and so that we just didn't have control of it.
Retrieving the exhibit. Now, Miss Gilmore, you go out into that pitch black night. Is there any light coming from anywhere at all?
Well, when the doors open, obviously the light's on in the store, so the light kind of shines out. So yes, there is some light coming from the store and shines on parts of, really kind of right on that loading dock area.
Now, how did you get that light out from the store onto the dock?
Just when you open the door.
How much was that door open, would you say?
That night, Riley was holding it halfway, what I would call halfway open. And so there was some light coming out that would really kind of shine right on the loading dock area, but not on the stairs.
I want to talk to you about those stairs.
Mhm.
When you were walking down them, could you see where you were stepping?
Just a little bit, but I'd been up and down those stairs a lot. So, I knew where they were, and I always kind of moved to the side, put my hand on the side of the wall and kind of use that as my guide as I walk down the stairs.
Was there a railing for you to hold on to help guide you?
No, ma'am.
Had you ever seen a railing back on that loading dock?
Not in the 10 years that I worked there.
Now, you said you went down the stairs. Did you make it to the bottom okay?
I did.
What did you do when you finished your cigarette?
Hurried back in because it was cold.
Did you make it back inside safely?
Did not.
All right, I want to walk through what happened after you finished your cigarette. What happened when you got to the landing of those stairs?
As I said, it was cold. Riley and I were trying to get back in. My foot, the corner wasn't there. I went to step down with my right foot on that corner, and the corner wasn't there, and I slipped and I fell.
Now I'm publishing what's already admitted as Exhibit 4. Miss Gilmore, can you tell us what this is?
Yeah, that is, I can't say, that's approximately the position of the door, whether it was an inch or two, one way or the other, don't know. But that was pretty much what the door was. Riley was blocking the wind. She was out there with me. That door was in that position, and I'm trying to scoot around that side, and you can see where the corner is really not there anymore.
Now, how much room would you guess you had between the edge of this landing and the door?
Maybe a foot. Enough. We obviously had been using that space and had been able to do it, but it was something that wasn't a lot of space there.
Retrieving the exhibit. Now, Miss Gilmore, you said that you fell after this.
Mm-hmm.
Where did you end up?
Fell off of the landing dock, off of that top stair, and I ended up on my rear end. I tried to avoid a worse fall, but still landed on both of my feet, but very much on that right leg because the ground is slanted, it's uneven. So I hit real hard on that right leg, and just my weight just couldn't sustain, and I buckled and I ended up on my rear.
Now, did your coworker come and help you at any point?
She did. Riley was such a sweet soul. She came down to check on me, and I said, no, I'm hurting, but I think I'm okay. Just help me get up and let's go back to work. And so we did.
Now, Miss Gilmore, did you ever tell the management at Chimes about this incident?
I did. We went in and told the manager, Miss Lane.
And what did Miss Lane say to you?
She said, gosh, we should have just, fixed those stairs years ago. I know it's a problem. So sorry. I don't remember the exact words, but, something to that effect that, she understood, thought she agreed those stairs should have been fixed years ago.
Miss Gilmore, to your knowledge, did Lane Kim tell the owners of Chimes about those concerns?
She said yes, that complaint had been registered, that the suggestion had been offered to them, and they just didn't fix it.
Thank you for your time, Ms. Gilmore. I pass the witness, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Gilmore.
How are you?
I'm doing well. How are you doing?
Doing fine.
I want to ask you about your time at Chimes department store. You worked there for 10 years, is that right?
Yes.
During those 10 years, the dumpster was always located in that back area, right?
Yes.
During those 10 years, you were always required to throw away trash as part of your job.
Mhm.
That's a yes?
Yes.
I apologize. I just need a yes for the
Yep.
record. So thank you for that. Yeah.
Yes, thank you.
During those 10 years, you threw trash in the dumpster at least once a shift, right?
Yes.
You also smoked the whole time that you worked at Chimes.
Yes.
You normally took at least one smoke break per shift.
Yes.
Now, between smoking and throwing away trash, you would estimate that you went out on that loading dock at least 20 times per week, right?
Yes.
This might sound like a silly question, but there are 52 weeks in a year,
Mhm.
right?
Yes.
So by my math, 52 times 20 means at least 1,000 times per year. Does that sound about right?
Yes, I think you ought to add in how many times those were in the day versus the night. So I take issue with your math in terms of the conditions.
We'll talk about the lighting a bit later, Ms. Gilmore, but 52 times 20, that sounds like it's at least 1,000, right?
I didn't work 52 weeks, but I agree with your premise in terms of on a per week basis. I was in and out and up and down a number of times. Yes.
Sure. So 1,000 times 10, that would be 10,000.
Yes. 1,000 times 10 is yes.
And you worked there for 10 years.
Yes.
Well, the first time that you ever went out on that loading dock, there wasn't a railing, right?
No.
Every single time you went out on that loading dock, there wasn't a railing.
No.
You actually pretty much never thought about that railing until January 23rd.
No.
After all, how could you put a railing on a loading dock? You'd say that, right?
On a loading dock, yes. On stairs is a different issue.
That's what you'd say. How could you put a railing on a loading dock?
Right.
You talked a few moments ago with Ms. Appler about those steps, right?
Mhm.
Is that a yes for the record?
Yes. Yes.
Thank you very much. Thank you. The condition of those steps, well, it didn't change significantly between the first time you ever walked out on that loading dock and the last time, did it?
No, but that night that wind was bitter cold. That was not a typical night for us. That was not a typical shift for us in terms of that particular trip outside. It was different than the average trip outside.
That night was different than the average trip outside?
Mm-hmm. Yes.
Okay. Well, I want to talk about the lighting situation as well. Now, you told us that there was an outdoor light that didn't work, right?
Yes.
But you did tell us as well that you could get some light from inside the building.
Yes.
And that lighting situation, that was the same the very first time you ever walked outside onto that loading dock.
Yes.
It's the same the very last time.
Yes.
Now, each of the times that you walked out onto that dock before January 23rd, you never fell, did you?
Did not.
I want to talk about January 23rd. Now, you said earlier that you had to scoot around that door. Is that right?
Yes. The door was open. I was hurrying. Riley was there. Yes.
That's right. You were hurrying.
Mm-hmm.
That's a yes?
Yes.
That's because, like you said, I think you said it was bitterly cold. Those are your words.
Yes.
I'm going to show you Exhibit 18, which is already in evidence. We're going to talk through the choices you had. Now, this is a photo with that door all the way closed.
Yes.
So when you reached the top of those stairs on January 23rd, you could have tried to push that door closed.
Riley was there. I couldn't have pushed that door closed. Riley was standing on the other side of the door.
You could have asked Riley to pull the door closed, right?
Yes.
Okay, let's talk about another option you have. I'm going to show you Exhibit 6, which is already in evidence. Now, this shows that door all the way open.
Yes.
Now, on January 23rd, when you got to the top of those steps, you could have pulled that door open, right?
Again, the wind was blowing so hard. Riley was there. We were both trying to get back inside. You know, if I don't know. I don't know I don't know.
You didn't try to pull that door
I
open.
did
at
not.
least.
I did not.
Let me show you Exhibit 3. This shows that door. We're on the other side of the door now, but this shows that door extending out across the walkway, right?
Yes.
This is how that door was when you tried to scoot around it.
Yes.
And that's when you fell.
Yes. With Riley holding the door. Yes.
Thank you very much for your time, Ms. Gilmore.
Any redirect?
No redirect, Your Honor. May Ms. Gilmore be excused?
She may. All right, who will be your next witness?
Your Honor, the plaintiff calls Mr. Kelly Danes to the stand.
Mr. Danes, if you'll please raise your right hand to be sworn. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, counsel, you may proceed.
Good afternoon, Mr. Danes. Can you see and hear me okay?
I can, thank you.
Can you introduce yourself to the members of the jury?
Yes, my name's Kelly Danes.
What do you do for a living, Mr. Danes?
I am a professional engineer.
What does that mean?
Well, in order to be an engineer, you have to pass exams, you have to go to school, you have to get your degree, and then there's a period of time that you have to work and get experience, and that's a 4-year period.
Mr. Danes, were you hired by my office to review this case and render opinions in this matter?
Yes, I was.
Did you come to any opinions?
Yes, I did.
How many?
Well, one main opinion, and there's some factors or kind of sub opinions, whatever you'd like to call them, some reasons that those opinions are supported.
All right, well, before we get into any of those opinions, I want the members of the jury to learn about your education and experience. Where did you go to college?
University of Wisconsin, go Badgers.
What degree did you receive from the University of Wisconsin?
BS in Bachelor of Science, in mechanical engineering.
Did you complete any further education or training?
Yeah, I'm a certified engineer, American Society of Mechanical Engineers, the ASME, and then I'm a certified builder from Scaffold Training Institute.
Now, are you a registered engineer here in Texas?
I am. National Council of Examiners for Engineering and Survey.
And where do you currently work, Mr. Danes?
I'm president of Danes Engineering, LLC.
What does your company do?
We investigate. We assist people with their problem solving and look at multiple engineering areas working throughout the United States.
How long has your company been in business?
This is year 10.
Mr. Danes, have you ever consulted as an expert witness before?
Yes, I do. I have, and I guess that consulting makes up a big part of our business. We're forensic engineers, so that's our job.
Would you say you testify more often for plaintiffs or for defendants?
I would say neither. It's pretty even division between the types of cases that we are retained to assist with.
Over the course of your career, how many incidents have you investigated?
I'm going to say 60, maybe a few more.
How many times have you been deposed?
Had my deposition taken probably 20 times.
And how many times have you testified as an expert?
I've been at trial testifying twice before this.
Now, taking a look at the work you did for this case, Mr. Danes, were you asked to determine whether Chime Department Store's designated smoking area was unreasonably dangerous?
That's what I was asked. Yes, ma'am.
So what materials did you review during your investigation?
I reviewed some depositions, Ms. Jordan Gilmore, who was the lady that was hurt, and then Ms. Reese Geller, who's a representative of the department store that owns that space.
Did you review any regulations or statutes?
I meant to tell you that also. Yes, I looked at OSHA regulations and IBC statutes and rules.
I want to break those down for a moment. Can you tell us what OSHA is?
Occupational Safety and Health Administration. Those are federal regulations.
And who is supposed to follow these federal regulations?
Every employer. The regulations are to protect employees.
You also mentioned something called the IBC. What is that?
IBC is International Building Code. That's safety regulations. Designing, building buildings, they follow a certain set of rules that are uniform.
Are these codes the types of statutes that you rely on in coming to your engineering opinions?
Yes, they are. They're standards.
Do you use any reliable methods during your investigations?
Well, I think the most important thing is to get pictures so that you can look at them carefully. We always, and I did here, go and inspect on site. So I made my trip down to Waco. I took pictures down there of the area in question in the building.
Is this inspection method standard in your field?
Absolutely, it has to be done.
Now, did you use and apply reliable principles and methods during your investigation of this case?
Of course, these are standards that apply, so that's what I used.
Is this the type of information used by experts in your field to reach conclusions and opinions in a case like this?
Yes, ma'am.
And those facts and data you mentioned earlier, were those sufficient in helping you come to your conclusion today?
Yes, along with the inspection.
And did you reach any conclusions to a reasonable degree of scientific certainty?
I did.
Your Honor, at this time, pursuant to Federal Rules 702 and 703, we tender Mr. Daines as an expert in the field of mechanical engineering.
Any objection?
None.
Proceed, counsel.
Mr. Daines, what is your opinion as to whether Chime's maintenance of their designated smoking area was unreasonably dangerous?
My opinion is that smoking area was unreasonably dangerous and contained significant safety hazards.
How did you reach that opinion?
Well, the three factors bear on that opinion. And when you look at all of them, they show together and separately how dangerous the area was.
Now, before we get into those factors, I want to make something very clear here for the members of the jury. Do you consider this designated smoking area to be a loading dock?
It is not a loading dock
Why do you say that?
because it's not used exclusively as a loading dock. It has multiple uses. They use that place to throw trash in the dumpster, and they had a rule, an employer rule that said take your smoke break in that area. So it's the smoking area, it's the trash area, and it's the delivery area. So it's not a dock.
All right, now, I want to talk to you about that first component that you considered. Was that the stairs in that area?
Okay, we can take up the stairs first.
Are you familiar with those stairs, Mr. Daines?
Certainly, yes, ma'am.
I'm publishing what's already in evidence as Exhibit 18. Can you see that okay, Mr. Daines?
I can see it fine, thank you.
Now, were these the stairs you inspected during your investigation?
They are.
And did you take any photos of these stairs?
I did. I took that one.
Now, did you reach any opinions as to whether these stairs complied with both OSHA and IBC standards?
Fails both.
How did the stairs not meet those standards?
These stairs, as are all, are required to have a railing. And you can see here that the railing has been removed. The second thing that's problematic is if you look on the right side of the stairs, you'll see that they are cracked and they have pieces broken off of them. That's unsafe too.
You mentioned the lack of a railing. How do you know that there's supposed to be a railing there?
Well, your OSHA standards, those are the ones, Occupational Safety and Health Administration, federal standards for employers. They say a stairway must have a guardrail or a railing on any exposed side. Not necessarily the side where there's the wall that's on the left, but it has to have a railing on the right side. That's an exposed one. And the IBC standards, International Building Code, same thing for people that build these kinds of things. You have to have a guardrail or railing.
Do you know if there ever was a guardrail or railing on those stairs?
You can see that there used to be. If you look at the top stair on the right side, you'll see that little deformity, maybe is a good word for it, where that rail has been cut off or removed.
Is that a problem?
Well, yeah, it's sticking out, and it's making the concrete crack and crumble there. So that's a safety hazard.
Retrieving the exhibit. I want to move on to that second component that you considered. Was that component those back exit doors?
I'm ready to talk about those. Yes, ma'am.
Did you reach any conclusions about those doors?
Those doors do not comply with IBC regulations.
Did you get a chance to inspect those doors?
I inspected them while I was on site.
Did you take any photos?
I did.
All right, I want to take a look at one of those photos you took, publishing what's been pre-admitted as Exhibit 4.
Yes,
So,
ma'am.
Mr. Daines, how do you know that these doors didn't comply with those IBC regulations?
Well, you can look immediately and see that it's obstructing the path up and down the stairs. And it's a very well-known IBC regulation that you're not supposed to obstruct that. You need to leave a space between where the door comes to its edge and the room that you have to get around that door.
Now, why is this specific door? Why is that door a problem?
Well, the way that works, if I'm coming up the stairs from the other side of this picture, how do I get around the door? I've got that little bitty space. It looks like, I think it's roughly a foot. And that's how much room I have to get around that door. That directly violates IBC regulations.
Is that safe, Mr. Daines?
That is not safe.
Retrieving the exhibit. Now, finally, Mr. Daines, I want to talk about that last component you considered. Was that the lights?
Yes, ma'am. Lights.
Did you reach any opinion about whether or not the lighting in that smoking area was safe?
I did reach an opinion.
What was that opinion?
The lighting was not safe. There are OSHA regulations about lighting in those areas, and it was not in compliance with those OSHA standards.
Did you inspect the lighting around the designated smoking area?
I did. I looked at it.
And can you tell us why that lighting didn't comply with those OSHA standards?
Well, there's a pretty simple OSHA rule. Lighting has to be adequate and appropriate for a building exit. And this, of course, is an exit, goes out the back and you're outside the building. And that's what OSHA requires, adequate and appropriate.
And why wasn't this lighting adequate and appropriate?
Because there was none, no working light on the exterior of the Chimes building that could be controlled.
You just said there was no working light. Was there a light fixture on the exterior?
You could see one out on that back wall, but you couldn't turn it on. So just hanging a light up there on the wall that doesn't give off light is not safe.
Mr. Daines, based on your investigation, your training, your experience, were the conditions of this designated smoking area safe?
They were not safe. There were numerous safety hazards that made it unreasonably dangerous for the department store employees at Chimes.
Thank you, Mr. Daines. I pass the witness, Your Honor.
Yes, ma'am.
Cross-examination.
Thank you, Your Honor. And good afternoon, Mr. Daines.
How are you?
I'm good. Thanks for
Good.
asking. I want to start by talking a bit about you and your work.
Okay.
You'll agree with me that 99% of the work you do involves lawsuits, right?
Yes, we're forensic engineers.
Involves being hired by lawyers.
Yes, we're engineers to be hired by lawyers to do these kind of investigations.
You get paid for your work in these cases.
Of course we do.
You've already made over $5,000 on this case.
Yes, ma'am. I think the actual number before trial began was about $5,600. I could be mistaken. Do you want me to look at the invoice?
No, that's all right. It's over
Okay.
5,000, isn't it?
Yes, ma'am.
And you're making more by testifying today, aren't you?
I get paid for the time that I am in court. Yes, ma'am.
This isn't the first time you've worked with Ms. Appler, is it?
I think I've had another case with her law firm.
That's right. She's paid you to testify for her before.
No, she's paid me to do investigations and consultations before. She didn't pay for testimony.
She does pay for testimony in that you get paid for the time you're testifying, right?
She's not paying for the testimony. She's paying for the time.
She's paid you for that time before.
Correct. Yes, ma'am.
Now, part of what you looked into in this case was OSHA regulations.
Yes, ma'am.
OSHA, that's the federal agency that does workplace safety.
That's right.
You've never worked as a code enforcement officer, though.
Did you say code and what? I'm
That's
sorry.
right. You've never worked as a code enforcement officer.
I'm sorry. Yes, ma'am. You're correct. I have not.
You never worked at OSHA.
I have not.
You told us about some conclusions you came to about OSHA regulations, right?
Yes, ma'am.
But of course, you would defer to OSHA about the interpretation of OSHA standards, wouldn't you?
In part, yes, ma'am.
I want to talk about your opinion that that back area should have had a railing. You believe that this area was not a loading dock. That's what you told us, right?
It was not a loading dock.
You'd agree with me that if it was a loading dock, no railing would be required.
On the loading dock part.
And that's because no railing is required on loading docks.
Well, that's an IBC regulation about loading docks. OSHA does not speak to loading docks in particular, not in the same way the IBC does.
So at least for IBC, there's no railing required on loading docks.
Well, that's right, and that's International Building Code, so the builders do not say that it is standard to put a railing on a loading dock. And so most people would follow that.
Well, you know that there were two ways into this building, right? Or
At
into the
least.
store, I should say. There are two ways into the
At
store.
least two ways into the store, yes, ma'am.
There's a front door, of course,
Front door, back door.
back door. And you know that that back door was the only place that the store could feasibly bring merchandise in, right?
Well, I understand that if you're a department store, you don't want trucks backing up to the front door and you don't want people rolling their carts in with all of your merchandise. But you said, is it feasible? Well, yeah, you can go in through the front door, but nobody would desire that. I understand. What you want to do is back up trucks to the back and put your merchandise in back there. That's probably where storage is anyway. Makes the most sense to use the back door. I agree with that.
As you just said, you understand using that back door to load merchandise.
Yes, ma'am. And
You
using
know-
our smoking area. That makes sense too.
You know that Chimes use that area as a loading dock almost every day.
Yes, and I know that from Ms. Gilmore's deposition. She said they got deliveries there every day.
So that's a yes to my question.
Yeah, I thought I said yes.
So you actually went out to Chimes to look at the area, right?
I did do an inspection on site. Yes, ma'am.
And in fact, even while you were there doing your inspection on site, a delivery arrived.
Yes, yeah, okay. There was a delivery. They brought a truck up. Some people brought some goods inside.
Even while you were there, that area was used as a loading dock.
Yes.
I want to move on and talk about the lighting in that area. You told us that the lighting wasn't up to code, right?
That's correct.
Now,
Not adequate and appropriate.
now the OSHA requirement about lighting is that the area be adequately lit, right?
Correct.
The IBC requirement is that the area be illuminated, right?
Same word. Yes, ma'am.
Neither of those regulations require a dedicated outdoor light, right?
They don't say that.
We can agree they don't say
Possible
that.
to comply without having one. I'm sorry, I keep talking over you. That's my fault. I'm sorry.
I'll try to stop too, but we can agree the codes don't say that.
They don't say you have to have an independent, separate exterior light.
I'm going to show you Exhibit 31. You actually took this photo, didn't you?
I did.
Well, thanks for doing that. I appreciate it. You'll agree with me, we can see at the top of this photo some big fluorescent lights inside that store, right?
Yeah, that's what those long tubes are. Those are fluorescent lights.
Now, you know that those lights work, don't they?
They're working right there.
That's right, they are, aren't they?
They are.
Now, you said something earlier when you were talking to Ms. Appler, and thank you, Ms. Smith. You said something earlier. You said the most important thing when you're investigating is to get pictures, right?
Correct.
You got a lot of pictures when you went to visit Chimes.
I did. I think I've turned all of them over. Everybody's seen them.
Mr. Daines, none of those pictures are of that back loading dock at night, are they?
No, they're not. I was there in the daytime.
You've never been there at night.
I have not.
You've never seen how well or how poorly that area is lit at night.
I have not seen that, and I did not take a picture of it.
I want to move on and talk about the door as well. Now, you told us it's a problem that the door extends into the walkway, right?
Yes, we looked at that picture earlier.
Now, you were there. You went to the scene, or not the
Correct.
scene. You went to the back area.
Yeah, I know what you're talking about. Yes, ma'am, I was there.
So you know that that door can close all the way.
Yes, it swings 180 degrees.
When it's all the way closed, it's not in the walkway.
When it's closed, the walkway, the staircase is not blocked if the door is closed.
When the door is all the way open, it's not in the walkway.
It's not in the walkway if it's entirely opened 180 degrees from the closed position.
Thank you, Mr. Daines. That's all.
Any redirect?
No redirect, Your Honor. May Mr. Daines be excused?
You may. Who will be your next witness?
Your Honor, at this time, the plaintiff rests.
All right. All right, ladies and gentlemen of the jury, we're going to take a recess before we continue. So we're going to take a brief 10-minute recess, and counsel, I'll have your trial times when we return. Okay, we'll be in recess for 10 minutes.
Thank you, Your Honor.
All right, let me just get a quick check-in from my jurors and make sure that they're all here. If you're on the jury, will you put your camera on for a minute and give me a thumbs up? 1, 2, 3, 4. Mark Man, where are you? There he is. Okay, thank you. Oh, there's Laura. Okay, good. I think I've got all of you. All right. Counsel, is there anything that we need to take up before we bring back in the jury?
Nothing from the defense.
Okay. I'm gonna bring our jury back in, and then defense, who will be your first witness?
Reese Geller.
All right, Ms. Skeller, if you'll please raise your right hand to be sworn. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, counsel, you may proceed.
Thank you. Good afternoon, Ms. Geller. Good to see you again.
Good afternoon. It's good to see you.
Can you tell us a little bit about yourself?
Sure. Well, my name is Reese Geller. I have lived in Waco my whole entire life, including going to Baylor University, where I got a degree in business. After college, I went to work in the department store owned by my family. It's a family business, and that is where I've spent my whole career. I'm married, and my husband and I have 3 children.
You mentioned that department store, that family business. Is that Chimes?
Yes, it is.
Can you describe Chimes just a little bit?
It is a department store, very much like Macy's or JCPenney's, but not as large. We sell a number of things: clothing, shoes, tools, a little bit of this, a little bit of that, but it's a Waco institution.
You said it's a family business. What do you mean when you say that?
The store was started by my grandparents, and then it was owned by my father. And now I'm the owner of Chimes. So it's been in the family for a long time. I'm very proud of it.
How long have you been the owner?
About 10 years now.
Can you tell the jury, in case they don't know, where is Chimes?
Chimes is on Bosque Avenue in Waco.
Can you describe just roughly the layout of that store?
Well, it's like many department stores, but it is in a strip center. There are a couple of stores on either side of Chimes. There's parking out in front, the front entrance. There's one entrance for customers to come in, and you go in, and I think we have a pretty good layout of things, making it easy for people to find whatever they might be looking for. The other exit is in the back, leads out to the loading dock, and I'm not sure what else you want me to talk about, but that's a description of the store.
That was perfect. Thank you. You mentioned the loading dock out back, and I do want to talk about that. I'm going to show you Exhibit 19. Now, am I right that that raised platform in the middle, that's the loading dock?
Yes, it is.
This might sound silly, but what is a loading dock?
Well, the name itself is pretty descriptive. It is an area where trucks can back up to and then unload whatever the truck might be carrying so that they can be carried into the store very easily. So it certainly is something necessary for us to have as a department store.
Is this how this area looked when you first started leasing this building?
Well, when we moved, we'd been at a different location, but we outgrew that space. And so my father found this space, seemed to be perfect space in terms of what we were looking for. And when we first moved in, there had been some railing that was out on what would be our loading dock, but then we asked that that be removed.
Thank you, Ms. Smith. You said you asked that that railing be removed. Let me ask you this. Can you run a department store without a loading dock?
Of course not. I mean, it would be virtually impossible because we have to have some way to get goods into the store. And I suppose you possibly could bring it in through the front door, but that would be inconvenient for everybody involved, the deliverers, as well as customers, as well as perhaps even the stores to either side of us. So we absolutely need a loading dock for convenience, for efficiency, for all sorts of reasons.
If you need a loading dock, Can you have a loading dock with a railing?
Well, no, if it had a railing around it, I don't know what it would be, but it wouldn't be a loading dock because it would make it very difficult, if not, I suppose you could get around it, but it would be very difficult and inefficient to try to have a loading dock that had rails around it.
Now, in addition to using that back area as a loading dock, did you also use it as a place for employees to throw out trash?
Yes, we did. There was a dumpster out there, and that was where we would dispose of trash that was in the store.
Did you also use it as a place for employees to take a break if they were going to have a cigarette?
It is a place that they could choose to go if they were going to have a cigarette. We certainly didn't want them smoking in the store, and we didn't want them smoking out front for all sorts of reasons. But either way, if they wanted to have a smoke break, that was the only place where they could go on premises.
Ms. Geller, how do you expect your employees to act when they're out on that loading dock?
Oh, I expect them to act like a reasonable person and to certainly look out for their safety, look out for anything. I mean, I expect them to act reasonably, I suppose.
I want to talk about the lighting situation out there. Are employees ever out there when it's dark?
Yes. Yes, they are. But I mean, if by dark you mean has the sun gone down? The answer is yes, because we are open and till the mid-evening or late evenings at different times of the year, and so it will be dark outside, but it's not dark out on the loading dock, because when the doors open, there are lights inside that shine light out to the loading dock, which would make it possible for people to see.
Ms. Geller, I want to be really clear about this. We have heard today that there was an outdoor light that didn't work. Did that worry you with respect to this area?
No, not particularly, because again, as I said, if the doors are open, the lights that are inside shine out to the loading dock. And so we've not had any problem with people being in the dark simply because the sun had gone down, because there was light out there.
I want to move on and talk about how often this area was used. So how often did you receive deliveries there?
Pretty much every day. We always are turning over inventory and we're getting deliveries of new things in. And so we were getting trucks virtually every day, several times a day on many of those days.
So if you're getting deliveries at least every day, employees are taking out the trash, taking smoke breaks. How often are employees going back there?
I couldn't give you an exact number, but many employees would be out there every day for any number of reasons, whether it's to receive deliveries or because they were taking a smoke break or taking out trash, or possibly even for their own reasons. But either way, I mean, there were people out there on a regular basis.
Have you been in this trial all day so far today?
Yes, I did see from opening statement on.
Did you hear me talk to Ms. Gilmore about how she might have used those steps as many as 10,000 times?
I did.
Is Ms. Gilmore just one of your employees?
Oh, yeah, we as I said, we're a department store. Well, we're not the largest department store that ever operated. We have multiple employees that are working at any given time. And I don't know how many of our employees smoke, but certainly there are always some, we always have some employees that need to go out there or choose to go out there to smoke. And trash has to be emptied, deliveries received. So yeah, there's more than one person. There's more than Jordan that's going out there.
How many years have you used that back area as a loading dock?
I think that it was pretty shortly after we moved there that we started using that area as a loading dock. So I want to say right about 14 years at the time of the accident. It's been a couple of years ago since that, but yeah, about that amount of time.
So in those 14 years, with all of your employees making all of those trips, can you tell us the number of accidents that have ever happened on those stairs, to your knowledge?
Well, there's the accident that we're here for today, but other than that, there was just one accident I don't know, 10 years or so ago.
Ms. Geller, what do you expect your employees to do if they see a safety issue somewhere at Chimes?
I expect them to notify someone so that we can address it. If we see a safety problem, we clearly want to address it. We don't want customers to get hurt. We don't want our employees to get hurt. We would take care of anything that we identified as a safety problem.
In the 10 years that Jordan Gilmore worked for Chimes, did she ever raise a safety issue with you?
No, I'm not to my recollection ever.
Thank you, Ms. Geller. Pass the witness.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Geller. Can you hear me okay?
I can't, thank you. Good afternoon to you.
Now, Ms. Geller, you've been at Chimes for the past 20 years, right?
Yeah, I guess it has been. Time flies when you're having fun, doing something you enjoy.
11 of those, you've been the owner.
Yeah, that's about right.
Fair to say, as the owner of this store, you want your customers to be safe when they're inside.
Absolutely. We do want our customers to be safe. We wouldn't stay in business very long if customers were getting hurt.
You also want your employees to be safe, right?
Of course we do. We want customers and employees to be safe.
And Ms. Forrester talked to you about the safety measures and programs you have in place in your store, and I want to make sure I've got this right. Chimes doesn't inspect the inside of the store for potential safety issues, does it?
Well, I suppose if you mean, are we doing some sort of formal inspection? The answer is no, we don't do a formal inspection. What we do is note if there are things, if there's something spilled that could be slippery or various other things, then we address it, but we expect that everybody will be on the lookout, and if they see those things, that they will advise someone so that, and that message will get to the people who can in fact fix anything that needs to be addressed.
Thank you, Ms. Geller, but I'm looking for a much more simple answer. You yourself don't inspect the store as the owner, do you?
Well, I'm at the store, but if you mean formal inspection, no, I don't do a formal inspection.
You don't do any type of inspection, do you?
Well, I don't want to be the person who's quibbling over a word, but when you say inspection, to me, that has a very precise meaning. It has involved, maybe a checklist or something like that, where you go down and then you periodically make sure. If you mean, do we do that? The answer is, I don't do that. On the other hand, if you mean, am I on the lookout for things that are happening in the store? The answer is yes. I'm in the store, I'm looking for things, I'm trying to look, do all those things that will make it likely that we will be profitable, and having safety issues would be one of those things that would detract from our profitability.
Now, Ms. Geller, I want to be clear here. Is it your testimony that Chimes does inspect the inside of your store for potential safety issues? Yes or no?
Well, I can't answer a question yes or no. As I said, maybe you should tell me what you mean by inspection, and then I can answer yes or no, but I can't when I don't know what you mean by that.
Ms. Geller, you remember giving a deposition on this matter, right?
Yes, I do.
You would recognize that deposition if I showed it to you here in court today?
Mm-hmm. Yes, I would.
Your Honor, permission to show this witness her deposition via share screen constructively outside the presence of the jury.
Proceed, counsel.
Ms. Geller, can you see this okay?
I have older eyes. If you could make it just a little bit larger, that would be helpful.
Absolutely, Ms. Geller. Just wanted to make sure you could see the whole page. Is that better?
Yes, it is. Thank you.
Now, this is your deposition, right?
You're scrolling a little quickly. Oh, yes, that is mine.
It was taken on June 1st of 2020?
It is. It was.
And this deposition was taken under oath, correct?
Correct.
It was done before someone named Guillermo Paquito?
Yes, I believe so.
And during the course of this deposition, you were told to be fair, right?
Mm-hmm. Yes.
You were told to be thorough?
Well, I mean, I'm not sure what you mean by that, but I was certainly told to be truthful.
And you were told to be complete, right?
I don't remember if I was told to be complete, but
Ms. Geller, during the course of your deposition, you were asked by counsel if there was anything that they didn't ask you that you'd like to include, right?
I believe so.
And Ms. Geller, this is your signature on the last page, isn't it?
Yes.
Directing the witness, opposing counsel, and the court's attention to page 10 of this deposition, I'm taking a look at line 9. Can you see that line highlighted in blue?
Yes, I can.
Please read along silently as I read aloud. Let me ask you this. Does Chimes regularly inspect the premises in or around its store looking for safety issues? Answer, no. We're not a safety company, we're a department store, so we wouldn't even know what we should be looking for. Did I read that correctly?
Yes. Yes, you did.
Retrieving the exhibit.
I'm sorry.
Retrieving the exhibit for the record, Your Honor. Now, besides being used for deliveries, Ms. Geller, this area behind Chimes was also where you kept the trash, right?
Well, where we kept the dumpster to put the trash, yes.
Your store employees throw away your business's trash into that dumpster.
Yes, ma'am.
And that requires them to go out the back door, doesn't it?
Yes.
Requires them to go down the staircase.
Well, that would be the smartest thing to do. I wouldn't advise them to jump, but yes, ma'am.
All right, now I want to talk to you a little bit about what you and Chimes knew before Miss Gilmore's accident. Now, your company maintains employee records, correct?
Yes, ma'am.
These records include workplace injury reports.
Yes, ma'am.
And your company labels these documents as recorded statement guides, don't they?
Yes, ma'am.
As the owner, you have access to those records?
Yes.
And you'd recognize one of those reports if I showed it to you here in court today?
I'm sure I probably would.
Directing opposing counsel and the witness's attention to what has been pre-marked as Exhibit 14. Can you see that, Ms. Geller?
Well, once again, my eyes are getting older and older, so if you could expand that a little bit, that would be a huge help for me.
If I can have opposing counsel, my co-counsel pull up a section. That looks like a section from that report.
Yes.
And you recognize it?
Yes.
Now, this report details an injury incident that occurred on January 12th of 2010, correct?
Yes, I believe that's the date.
This record is kept within the course of regular business at Chimes?
Yes.
This record was made by someone named April Nardini, correct?
I believe so, yes.
She was the store manager at the time?
Yes.
And it was regarding an incident involving another employee, right?
Yes, ma'am.
That's Jason Stiles?
Yes, ma'am.
And this is a fair and accurate copy of that record?
As far as I can tell, I don't have any reason to doubt that.
Your Honor, at this time, plaintiff offers Exhibit 14 into evidence.
Any objection?
No objections.
All right, it'll be admitted.
So publishing this to the jury then, Ms. Geller, this is an injury report regarding a prior Chimes employee, correct?
Yes, ma'am.
This report indicates that an accident occurred on January 8th of 2010.
Yes, ma'am.
Now, directing your attention to this pullout that we have here where it says accident loss, can you see that okay?
Yes.
Now, it reads the following. I was out back on the loading dock. My supervisor, April Nardini, asked me to take out some trash and throw it in the dumpster behind the building. It was dark outside when I opened the door and the light wasn't on, so I went back in and asked April where the light switch was. She told me there was no switch for that light in our store, and that the only switch for that light was in the store next door, so there was nothing she could do about it. She told me just to leave the door open and use the light from inside the building so I could see where I was stepping. I did exactly that, but as I was walking down the steps, I slipped on what I think was loose concrete and I fell face first onto the ground at the bottom of the steps. There was nothing for me to grab onto, so I couldn't stop my fall. Did I read that correctly?
Yes, ma'am.
Now moving on to the final page, this last item. If we can blow that up there, can you see that okay, Ms. Geller?
Yes.
Now this form asks, are there any steps that should be taken by Chimes to help prevent such injuries in the future? That's what it says, doesn't it?
Yes.
And the supervisor who completed this form wrote, make sure there is adequate lighting on the loading dock. Did I read that correctly?
Yes, ma'am.
Retrieving the exhibit. Ms. Geller, I want to talk to you about what you did in the 9 years between this incident and Ms. Gilmore's incident. After this incident in 2010, excuse me, you didn't install a new outdoor light by those steps.
Well, I mean, the answer is no, we weren't allowed to do that with, that wasn't our area.
But you didn't install a new outdoor
We
light.
did not. We did not.
You didn't even put a flashlight by the door for your employees to use, did you?
No, we did not.
You didn't send out a memo warning employees to exercise caution on those stairs at night?
We try our best to hire good employees that we don't need to tell them to do what is obvious, which is to be careful around steps. So no, we did not.
So to be clear, you didn't send them a memo telling them to exercise caution at night?
We did not.
You didn't post a warning sign?
A warning sign saying what?
You didn't post a warning sign about the lack of the guardrail on those stairs?
We didn't post a sign to say the obvious. No, we didn't.
You didn't post a sign to say exercise caution even?
Once again, we thought, I've never seen a sign on most stairs saying exercise caution. People are familiar with stairs and recognize that they can fall down steps. So no, we didn't do what seemed obvious in terms of warning someone of an obvious danger.
Ms. Geller, you didn't change a single thing about your safety policies in the 9 years before Ms. Gilmore's accident, did you?
Well, we didn't have a safety problem, so the answer is no, we didn't. We hadn't had any problems, so no. The employees knew what the loading dock was like, and so no, we didn't.
Thank you, Ms. Geller. I pass the witness, Your Honor.
Can you redirect?
No redirect, Your Honor.
May this witness be excused?
Yes.
All right. Thank you, Ms. Geller.
Thank you.
Who will be the defendant's next witness?
It will be Perry Hayden, Your Honor.
All right. And I failed to give you all your time. So before we swear in our next witness, let me just give you an update. You all have plenty of time, but after that last examination, I have that the plaintiff has used 43.5 minutes and the defendant has used 32 minutes. So lots of time left. All right. All right, Mr. Hayden, if you'll please raise your right hand to be sworn. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, counsel, you may proceed.
Good afternoon, Mr. Hayden.
Good afternoon.
Can you tell the jury what you do for a living?
I'm a compliance and safety and health officer for the Occupational Safety and Health Administration of the federal government.
Now, the Occupational Safety and Health Administration, is that OSHA?
That is OSHA, yes.
What does OSHA do?
OSHA is charged primarily with making sure that workplaces around the country are safe for employees. We kind of do that in two ways. We offer sort of guidance to employers and employees and developing safe premises for their workers. But then we also have an inspection program. We routinely inspect workplaces around the country for compliance with OSHA standards and regulations.
How long have you been working as an OSHA inspector?
This is my 14th year.
Do you have any relevant educational background to do that job?
I do. I have a degree in occupational safety and compliance technology, and then I've got a second degree in environmental technology compliance.
Mr. Hayden, over the 14 years that you've worked for OSHA, can you give us an estimate of how many workplace inspections you've done?
Well, an estimate would be I do probably, I guess, a minimum of 100 of these a year. And so over 14 years, if I'm doing 100 a year, that's certainly over 1,000.
Well, out of those, at least 1,000 inspections, I'm going to ask you about one of them in particular. Did you do an inspection of Chimes department store back in 2018?
I did.
When you did that inspection, what kinds of materials and information did you have?
Well, I just bring with, my training from OSHA in terms of standards and practices that are in compliance with our regulations. But then I basically just do an on-site inspection, explore the work premises and investigate and make sure things that I see that are available to me to look at are in compliance with our standards.
Is that a method that most OSHA inspectors use?
Yes, that would be the method that anybody who's inspecting a workplace would be expected to comply with.
Now, are there any differences that you're aware of between how you inspect a workplace and how other OSHA inspectors do that?
I mean, not in terms of the basics. I mean, I'm probably, I don't think that it's appropriate for OSHA to sort of set quotas for citations, and there's not, if I don't issue enough citations, then I'm not doing my job. And so I call it like I see it. If I'm inspecting a premises, my primary concern is the safety of the employees. I mean, in my book, the employees come first. And so I hold employers to the regulations as I have been taught to interpret those regulations.
Now, without yet telling us what your conclusions were, can you tell us whether you came to any conclusions when you did that inspection of Chimes?
I did. I filed a report.
Right. Defense offers Perry Hayden as an expert in workplace safety compliance.
Any objection?
Yes, Your Honor. I would object under 702B. May I be heard?
Yes.
Your Honor, at this point, we haven't heard whether or not there were any facts and data that were sufficient for Mr. Hayden to come to a conclusion today. Furthermore, merely using these statutes that he cited has not been established as essential to his investigation, or whether or not these particular statutes were reliable for this investigation. And that foundation needs to be laid before he can be tendered as an expert today.
Response?
Your Honor, Mr. Hayden said that he did an investigation of Chimes back in 2018. That's enough to know that he collected information while he was there at the scene. And he just told us that what his method is to look at these workplaces, compare them to the OSHA regulations, and determine whether or not there are any issues. That satisfies all of 702.
All right, the objection is overruled. Proceed, counsel.
Mr. Hayden, before we get into your inspection, let me ask you, why are you here testifying today?
I was summoned to be here.
When you say you were summoned, do you remember getting a subpoena?
I guess that's the legal term, yes.
And that just means, well, I'll ask you this. Did you choose to be here?
No, but I didn't want to go to jail.
And am I or anyone else paying you to be here today?
No.
Well, let's go ahead and get into the meat of your inspection. When you inspected Chimes in 2018, what areas of the store did you inspect?
The interior, obviously, where the sales were transactions, the stock room where goods were stored. And then because I was told that employees did do work out on the back of the building, I looked out there as well where the loading dock is.
I want to talk about your inspection of that loading dock area. I'm going to show you Exhibit 19. Is this how that loading dock looked when you visited?
Yes, as far as I remember, yes.
So when you first arrive and you first see this loading dock, what are your first impressions?
Well, initially, I came at it from the other side, inside, walking out, my initial reaction was, where's the railing? But at that point, I was made aware of the fact that this space was used as a loading dock. And that then changed my view of the railing issue.
Thank you, Ms. Smith. You said when you heard that this area was used as a loading dock, that changed your opinion about the railing issue. Can you explain why that is?
Yeah, OSHA does not require safety railings to be part of a loading dock area for reasons that we've already heard. Obviously, if there's a fence basically up on the loading dock, you can't use it to load to offload product. I mean, the idea behind the loading dock is the height of the loading dock matches the height of the trailer that will be supplying the goods. And it's very critical because a lot of times you have large goods or goods come in large containers and stuff that can't be hand lifted off. They have to be two-wheeled off or sometimes a pallet jack. And so you have to have the vehicle match up with the store point of entry so that you can unload them off the trucks. And so if you put a gate up there, then that's not going to happen.
I want to talk about another part of that back area. Did you notice anything about the steps?
Yes, the steps. There was some decaying in the concrete on one of the edges of the steps.
I'm going to show you Exhibit 18. Does that represent the decaying of the concrete that you mentioned?
Yes.
Mr. Hayden, could you estimate for me a percentage of that step that decaying is happening on, at least for the top step?
5%.
Did that rise to the level of an OSHA violation?
It did not.
Thank you, Ms. Smith. I want to talk about the lighting as well. What is the OSHA regulation about lighting around exits?
It requires that workplaces be adequately lit.
Does that require a dedicated outdoor light?
No, not at all. It just requires adequate lighting, and that adequate lighting can be provided in a number of ways other than a dedicated light.
Mr. Hayden, in the course of your inspection of Chimes department store, did you see anything else that rose to the level of a violation?
I did not.
Are you familiar with an OSHA regulation that requires workplaces to maintain a safe workplace for the employees?
Yes, I am.
Were you considering that regulation when you inspected Chimes?
Yes, of course. And there was nothing that I saw during my time inspecting the premises, the work premises at Chimes, that I considered to run afoul of that.
Throughout your whole inspection, did you issue a single citation to Chimes?
I did not.
Thank you, Mr. Hayden. I pass the witness.
Cross-examination.
Yes, Your Honor. Good afternoon, Mr. Hayden. Can you hear me okay?
I can.
Now, Mr. Hayden, you're a compliance, safety, and health officer for OSHA, right?
Yes,
That's a federal government agency.
it is.
And it's your job to visit businesses in your area to ensure their compliance with OSHA, right?
Yes,
And you then determine whether they're in compliance, don't you?
based on my training and the provisions of the regulations that I'm charged with enforcing, yes,
Now, you do these inspections alone, correct?
I do.
So you alone have that discretion of whether or not this business complied.
At the individual workplaces that I inspect, that is true.
Now, as a government employee, you want to ensure that you do a thorough inspection every time, right?
I always do a thorough inspection.
You want to do a complete inspection every time.
I do what I'm charged by OSHA to do when I inspect workplace premises.
And that's because you want to ensure that employees are safe in their workspaces, right?
That's my goal, yes.
I want to talk to you about some of your inspection practices. Now, your experience specifically is with OSHA regulations, right?
It is.
OSHA's guidelines for safety?
It is, yes.
Not any other government agency's guidelines, right?
I don't work for the other governments, no.
Not any other state guidelines.
I don't work for a state.
You haven't been trained in any other federal agency's inspection practices, right?
I've been trained for OSHA and OSHA only.
So when you do these inspections, you'd agree you're looking for OSHA and OSHA only violations.
That is correct.
Mr. Hayden, you'd say you're a pretty lenient inspector, right?
I would not say I'm a lenient inspector. I would say I was a reasonable inspector.
Well, you're fairly conservative when it comes to issuing citations, aren't you?
Well, conservative doesn't mean lenient. That's your words.
But you'd say you're conservative in issuing citations.
Well, if not issuing thousands of citations every time I go someplace is conservative, then I guess I would agree with you. Define conservative for me, though.
Actually, I'm going to talk to you about your investigation of Chime's department store. Now, that was on May 5th of 2018, wasn't it?
It was.
And prior to 2018, you'd say it's been a while since you'd been out there, right?
Yes, I don't live in Waco.
That's why you went out there in the first place, isn't it?
I was assigned that store to inspect. Yes.
Now, you completed this inspection alone, right?
Yes.
You completed it during the day.
Yes.
And over the course of this inspection, you spoke with the manager of Chimes, right?
Yes. That's the protocol.
And she told you about that back smoking area.
She did.
And ultimately, you didn't issue any citations for that back smoking area.
It conformed to OSHA requirements, so there was no reason to issue a citation.
Okay, well, I want to talk to you about that back area then. Now, Elaine Kim, the manager, told you that employees regularly work in that area, correct?
That is correct.
She told you they take smoke breaks there.
She told me that, yes, she did.
And like you said on direct examination, your first impressions of that area, you were pretty alarmed, weren't you?
Because I didn't know it was a loading dock. Yes.
You'd say you saw some pretty obvious issues.
I saw the issue I saw before I knew it was a loading dock was there was no railing.
But first impressions, some pretty obvious issues.
Well, I mean, uninformed first impression, I saw the potential for a problem. Yes.
Now, Mr. Hayden, you notice the steps on the landing were cracked, right?
Well, the steps weren't cracked. On a couple of the steps, there was a corner that was chipped.
They were eroding away.
Well, they were chipped. I mean, the 95% of each step was complete and had no problems with it.
Now, you said that you were alarmed about these things, but you didn't mention any of those concerns when you spoke to the manager later, right?
Well, after I had been told how that's part of the premises were used, those concerns, as I indicated, were dispelled.
But prior to learning that it was a loading dock, you didn't bring up those concerns with Lane Kim.
Well, it was all at one time. I mean, I'm brought out to the back of the building, and that when they opened the doors, I see this space, elevated space with no railings. And I think to myself, this is going to be a problem. And the manager says, this is our loading dock. It was simultaneous.
So based on just the fact that she told you it was a loading dock, that's why you didn't issue that citation, right?
That is correct.
I want to talk a little bit more about.
It complied with OSHA regulations as a loading dock.
Thank you, Mr. Hayden. I want to shift gears now and talk a little bit more about how you conducted your investigation. You didn't speak to any employees other than Lane Kim, correct?
Yes, that's right.
You didn't speak to the owner of Chimes.
No, I did not.
And over the course of your inspection, you didn't take any pictures, right?
I did not.
Didn't take any videos?
I did not.
Didn't take any measurements?
There was nothing to measure.
Look, for instance, you didn't measure how far that door swung open, right?
I did not.
Didn't measure how high up that platform was?
It was less than 4 feet. I could tell that, but no, I didn't make a precise measurement.
You say it was less than 4 feet. That was just because you eyeballed it, right?
Yes.
You also didn't inspect this area at night, did you?
Well, we inspect the premises when we get there, and we expect them under the conditions that that are in existence when we're there. We don't stay there 24 hours a day and do do a daily cycle of how the premises are used. That's not the way OSHA inspects premises.
I'm not asking about a daily cycle, Mr. Hayden. I'm just asking, you didn't complete your inspection when it was dark outside, right?
Well, I completed my inspection, but it was not dark outside when I completed my inspection, yes.
Now, when you were outside, you noticed that exterior light, right?
I did.
Your Honor, I'm republishing what's already in evidence as Exhibit 2. Can you see that okay, Mr. Hayden?
Yes, there's a circle up there on the left, right?
Let's talk about that circle. That circle is around the light that you saw.
Yes,
You actually asked Lane Kim, the manager, about this light.
I did.
And she told you that they always turned this light on when somebody goes outside at night, didn't she?
Well, I was told that it was automatic lighting that came on during the dark, I believe, is what my report indicates.
So she told you that this light always turned on when someone went outside.
I believe that's what my report indicates, yes.
But she didn't turn that light on for you to show you that, did she?
Well, if it was automatic, it would not have come on during the day. It would have been set to come out when it got dark. That's what an automatic light does.
But you never checked to actually see if that automatic light was working?
Well, I didn't stay around until the sun went down, if that's what you're asking. No, I didn't.
I'm just asking whether or not you even tried to turn that light on and off.
Well, I couldn't have turned the light on or off because it was an automatic light. And so until it got dark outside, until the conditions outside were sufficient that it triggered the mechanism in the light to go on, there was not much I could do.
So you didn't bother to wait around to see if that was the case?
Well, I mean, I don't know what your impression of government employees are, but we don't waste time. You know, we go do our job and then we move on.
And all this was part of your thorough and complete inspection?
It was.
Thank you, Mr. Hayden. I have nothing further, Your Honor.
Can you redirect?
No, Your Honor.
May this witness be excused?
Yes.
All right, thank you, Mr. Hayden. Who will be the defendant's next witness?
Nothing further from the defense. We rest our case in chief.
All right, does the plaintiff have a rebuttal case?
No, Your Honor, we do not.
All right, so everybody rests and closes. Counsel, do you need a break before closing arguments?
Your Honor, prior to closing arguments, we were wondering whether or not the court would like to discuss the jury instruction that will be used during closing arguments, either before or after the break.
Right, I have a few matters definitely to take up with you. My question is, do you need another break before we take those up, or no? Are you ready to proceed?
If we could take 5 minutes just to grab some water, that would be great, Your Honor.
All right, ladies and gentlemen of the jury, we're going to take a 5-minute break. Try to be back just a little bit early, and we'll be in recess for 5 minutes.
Thank you, Your Honor.
All right, I see my lawyers are back. Let's see about my jurors. Here we come. Here they come. 1, 2, 3, 4, 5, 6. All right, thank you, ladies and gentlemen of the jury. All right, counsel, constructively, the jury is not yet back, okay? So let's take up, let me give you your times real quick. Plaintiff has used 52 minutes and 11 seconds, and defendant has used 41 minutes and 25 seconds. So still plenty of time. Feel free to give some of it back to the court. No. Okay, and so it's time for the charge conference. I know that I have several versions of the charge, so let me hear argument on which one each of you proposes.
Yes, Your Honor. The plaintiff proposes jury charge number 4.
All right. What about the defendant?
The defense proposes jury charge number 2, and I'm happy to explain why.
Okay, so let me hear from plaintiff first about your charge, your proposed charge. Proceed.
Yes, Your Honor. Your Honor, we propose this charge be used as it addresses the negligence and the liability of the defendant directly. Now, to use jury charge number 2, which would include a comparative negligence affirmative defense from the defense, would be improper today. Now, to establish this affirmative defense, Ms. Forrester had to establish the prima facie case for comparative negligence. She hasn't been able to do that today. Therefore, to give this charge to the jury, to present it to them and say that they've established this case would be improper and would go to confuse them. Therefore, we ask that jury charge number 4 be used instead, which addresses liability of Chimes department store directly.
Okay, response?
Yes, Your Honor. The defense has certainly shown a prima facie case that Ms. Gilmore acted negligently. Now, the standard is that she didn't act with a duty of ordinary care, and Ms. Gilmore's own words were enough to show that she didn't. She said she was hurrying that night. It was clear that she could have closed the door or opened the door. She chose not to. There's certainly enough that a reasonable juror could find that she acted negligently in a way that contributed to her injury. And that's why we should use the jury charge number 2, which has both Chimes and Jordan Gilmore listed as in a comparative negligence setup.
All right, thank you, counsel. We are going to go with jury charge number 2. All right, is the plaintiff prepared to proceed with closing arguments?
Yes, Your Honor.
Okay. All right, counsel, you may proceed.
May it please the court. Counsel, members of the jury. Carelessness creates consequences. When people are careless, when they go through life with a disregard for safety, they can hurt others. You'll learn today that we're not here because of a careless person. We're here today because of a careless company. Today you heard that the defendant, Chimes department store, chose to be careless. You learned that Chime chose their image over their employees, their profits over their people, and that one of their most dedicated employees, Miss Jordan Gilmore, suffered the consequences of their carelessness. Now, you learned today that we're here because Miss Gilmore suffered an injury while she was working as an employee of Chimes department store. You learned that on January 23rd of 2019, Miss Gilmore was injured because of the defendant's negligence. We had to prove that to you today by a preponderance of the evidence. You might be asking yourselves, what does that even mean? And in a moment, the Honorable Judge Mitchell is going to come before you. She's going to give you a set of instructions. And these are called your jury instructions. Now, she'll tell you about the questions that you have to answer today, and she'll tell you what the law really means. Now, Judge Mitchell will tell you that we had to prove 3 things today in order to prove that the defendant was negligent. So let's take a look at what those 3 things are. First, we had to prove that the condition in question posed an unreasonable risk of harm. Second, that Chimes Department Store Incorporated knew or reasonably should have known of the danger. And third, that Chimes Department Store Incorporated failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of the condition and failing to make that condition reasonably safe. Now, I know that that can all sound a bit confusing, a lot of legal terms. So I'm going to break it down for you, piece by piece, step by step, element by element, and show you how we proved every single one of those things to you today, and that we proved them by a preponderance of the evidence. Now, members of the jury, that just means more likely than not, a mere tipping of the scales. So let's talk about how we met our burden today. I want you to think back to the start of today's trial when Miss Gilmore took the stand. You met her today, and Miss Gilmore told you about when she proudly began her job as an employee of Chimes Department Store. You learned that she dedicated 10 years of her life to working hard as a cashier for the defendant, always trying to follow the rules and just be a stand-up employee. You also heard that in 2015, the defendant enacted that new policy, that smoke break policy. Miss Gilmore told you about it, and she showed you this memo. And she told you that the defendant's new policy required that all smoke breaks be taken behind the store, near the back door. You heard what smoking out back really meant for employees of Chime. You heard about the dangerous conditions that the defendant subjected their employees to. You saw that any employee who wanted a smoke break, including Miss Gilmore, had to stand here on this exposed concrete platform behind the store, right beside the dumpster, a platform that was falling apart, a platform without a handrail, without adequate lighting, a platform with chunks missing from it, with pieces of metal sticking out of it. You learned that this was the area that Chimes chose as their designated smoking area for their employees. You heard from their owner today, Reese Geller. She never inspected it for safety concerns. In fact, she tried to bend the truth about that on cross-examination today. She told you she doesn't even know what that word inspection means. Members of the jury, the owner of Chimes doesn't even know what to look for when it comes to safety hazards in her store. They were careless. We've met those first two elements. Those conditions that you just saw posed an unreasonable risk of harm, and the defendant knew about them. They knew that those conditions were dangerous, and they ignored them. They were careless. So let's talk about what they knew. Now, you saw that light outside that's circled in red here. The light that the defendant knew didn't work, knew was a problem, but that they left up, with no switch available to employees when Miss Gilmore was an employee. You also saw this tiny bit of concrete, this few exposed inches that employees had to navigate around that door if it was open. Look closely at this image, members of the jury. Look at that exposed pipe, that protruding metal, the missing concrete, that deformity. These were the conditions the defendant knew they were leaving for their employees. And you heard what happened to Miss Gilmore. With no guardrail to catch her, Miss Gilmore fell off that exact platform, landing on her right leg, damaging her right knee. Miss Gilmore told you, after that fall, she had to have her entire right knee replaced. All because the defendant chose not to prioritize the safety of their employees. You also heard testimony from an expert witness today, Mr. Kelly Danes, a mechanical engineer. Mr. Danes took the stand and he told you about his experience in engineering, his experience working with federal building statutes. And his testimony made it clear that Chimes Department Store violated numerous federal guidelines, those that governed handrails, that governed lighting, that governed staircases. Mr. Daines told you this area was unreasonably dangerous. It was filled with safety hazards. And the defendant knew that. They knew that platform was dangerous. They knew that those stairs weren't safe. They knew that that lighting was inadequate. But they didn't do anything to fix it. They couldn't be bothered to make this area safe. This area that was used not only by smokers, but even by other employees who just had to go take out the garbage, or employees who had to load and unload shipments. The defendant didn't just put Ms. Gilmore at risk. They put all their employees at risk. Remember how evasive Ms. Geller was on the stand today. She didn't know what it meant to inspect for hazards. It's no wonder this store was so dangerous. You also heard about that prior incident where another employee fell without lights, without a hand railing, on that exact same staircase 9 years before. They let 9 years go by without making a single safety change. Ms. Geller told you they had no warning signs. They didn't send out a memo about that incident, about using caution. They breached their duty to Ms. Gilmore and to their employees, their duty to protect them from danger, to make their workplace safe. They violated that duty. Remember the words of Ms. Gilmore's manager. We should have gotten those stairs fixed a long time ago. We've proven that third element to you today, members of the jury. We've proven that they were negligent. We've met our burden. Now, in a moment, the Honorable Judge Mitchell is going to tell you about the questions that you have to answer today. So let's take a look at them now. First, she's going to show you this first question. And it asks, did the negligence, if any, those named below, proximately cause the occurrence or injury in question? And here there are two parties listed, Chimes Department Store and Jordan Gilmore. And here, members of the jury, you can write yes right beside Chimes Department Store, because you know now they caused Ms. Gilmore's injury. And you have to write no under Jordan Gilmore's, because you know that Ms. Gilmore didn't cause her own. Now that means that you have to move on now to question number 2. And Judge Mitchell will tell you this second question asks, for those found by you to have caused the damages, if any, to Jordan Gilmore, find the percentage caused by, and it lists Chimes Department Store and Jordan Gilmore once again. Now here you have to fill in the percentages. You have to make sure they add up to 100%. And that'll be easy, members of the jury, because, well, you can write 100% next to Chimes Department Store and 0 next to Jordan Gilmore. The evidence showed you today the defendant chose carelessness, chose ignorance, even chose laziness over their employees, over safety. And Ms. Gilmore suffered the consequences of their carelessness. And that's why we ask you to look at the facts, to look at the evidence and to apply the law, and to find the only verdict that's supported by the truth. We ask you to hold the defendant, Chimes Department Store, liable. Thank you.
All right, the court will recognize defense counsel for closing argument.
Thank you. The steps were safe if the employees were safe. Folks, by now, I don't have to tell you which steps I'm talking about. You've seen those steps probably more than a dozen times throughout today's trial. And perhaps the most notable thing about those steps is that they're not notable at all. They're ordinary. They're average. The evidence showed they were not dangerous. They were safe as long as the employees were safe. Today you heard about the defendant Chimes department store. You heard about Reese Geller. You met Reese Geller, the owner of that store. She told you about Chimes moving into that location back in 2005, about how they looked around the store. They saw a front entrance, a back entrance. What they knew they needed was a loading dock. They put one in. They took down that railing. They paved a driveway. And for 14 years, 14 years, daily deliveries, daily smoke breaks, daily trash removal, 14 years and so many employee trips. You heard there were just two times that someone fell down those stairs. Folks, you heard that Ms. Gilmore herself took those stairs nearly every shift for 10 years. She didn't have a single problem until January 23rd. You heard what was different on January 23rd. You'll remember that Ms. Gilmore herself was the person who told you that night was different. That night was cold, she said. That night she was hurrying, she said. And as she was hurrying in from that cold that night, folks, she wasn't careful. She didn't look where she was going. And she got hurt. Folks, what happened to Ms. Gilmore is awful, of course. But this is a negligence case. It is the plaintiff who has chosen to bring that case. And that means that the law says that they have to prove every element of that claim. I'm going to walk you through those elements. We're going to talk about how they didn't do that. And they had to prove, number one, that there was an unreasonable risk of harm. Number two, that Chimes knew or reasonably should have known of the danger. And number three, that Chimes failed to use ordinary care to protect their employees. And folks, they had to prove all of these by a preponderance of the evidence. They had to prove they were more likely than not to be true. If they didn't show that even a single one of these three things was more likely than not to be true, that's it. They haven't met their burden. Let's talk about these. Let's start with number one, unreasonable risk of harm. Unreasonable. I want you to remember that word. The law doesn't require no risk at all. The law just doesn't allow an unreasonable risk. So what is an unreasonable risk? It's a risk that isn't balanced or outweighed by other things. Things like benefits, things like necessity. Now, of course, everything in life is going to have some risk. Every time you get in your car, leave your house, there is some risk. We take risks in life because of the things we get back, because of those benefits, or because they're necessary. I want you to remember when Reese Geller took the stand. She came before you today. She told you all about her family business, how she is the third generation to be running Chimes department store. And folks, she explained to you why they got rid of that railing. It wasn't just for fun. It wasn't just because they felt like it. There was a reason, a good reason. And the reason was that, as she told you, you can't have a department store without a loading dock. And you cannot have a loading dock with a railing. She said, well, then it just wouldn't be a loading dock. That's not how it works. They had to get rid of that railing, folks. And the thing is, the law on this point is reasonable. The law recognizes that. You will have the benefit of this law this portion of the International Building Code, when you go back to deliberate today, you'll see that this law, it has an exception. It does not require guards or rails on the loading side of loading docks. It doesn't require that because that would be nonsensical. It would be ridiculous. It just doesn't make sense. Folks, not having a railing, that is not an unreasonable risk. The plaintiff didn't prove that to you. Now, there were other issues that they brought up. They brought up issues with the lighting. You heard today that there was an outdoor light on the side of that building that didn't work. We have not tried to dispute that fact. But there was not a single person in this trial, not the plaintiff's expert, not our expert, not a single person who told you that that outdoor light needed to be working. You heard what those regulations were. Lighting has to be adequate. The area has to be illuminated. You didn't hear a single piece of evidence that that wasn't true. In fact, you heard the contrary. You heard that there were giant fluorescent lights inside that building. You heard that the doors opened 180 degrees flat to the sides of the outside walls. That light could spill out at night. It could adequately light that area. It could illuminate that area. Now, it's going to be important today, when you deliberate, for you to remember to hold the plaintiff to their burden. They had to prove this element, not us. And so in doing that, I want you to think about the plaintiff's expert, Kelly Danes, who came before you, talked about that investigation he was paid to do. He told you in that investigation he was paid to do that the most important thing for him to do was to get pictures. He told you he didn't get a single picture of that loading dock at night. They came in here and told you over and over and over again, it was too dark at night. It was too dangerous. There wasn't enough light. You didn't see a single photo of that. They didn't meet their burden. Folks, you heard about issues with a door. And it's true, you saw that door, it swings out into the walkway. But that's the thing about doors. They open, they close. Even Mr. Danes told you when that door was open, it wasn't in the walkway. He told you when that door was closed, it wasn't in the walkway. The railing, the light, the door. Not a single one of those was unreasonable. Simple as that. Now, we are not pretending that there was no risk. I'm not saying that. But what we are saying is that the risk that was there was necessary, and the risk that was there was reasonable. And what that means is that the plaintiff has failed. They had to prove every one of those elements, and folks, on the first one, they failed. That's it. Show's over, case closed. But if you have any lingering doubts or hesitations in your mind, I'm going to talk you through the other elements too. I'm going to show you how the plaintiff failed on those counts as well. Now, second, they had to show that Chimes knew or should have known of some kind of risk. But when did you hear that today? The answer is that you just didn't. Again, I want you to think about Ms. Geller. I don't know about you, but to me, Ms. Geller seems like the kind of person who genuinely cares about her employees. I asked her if Ms. Gilmore had ever brought her any concerns. She said she hadn't. Folks, I want you to think, really think about, first of all, the 10,000 trips down those steps that Ms. Gilmore took, multiplied by the number of employees who might be in that store, multiplied by the number of years that area has been used as a loading dock. That's 14. We're talking tens of thousands, maybe hundreds of thousands of trips down those steps in the light, in the dark, in the rain, in the wind. Out of those tens or hundreds of thousands of steps, just two times did someone fall down those stairs. Folks, that might be better odds than the staircase in your home. That is not an unreasonable risk. The plaintiff did not show the defendant should have known about that risk. They failed on that second element. So we could talk about the third element for just a moment. They had to show that Chimes didn't use ordinary care to protect its employees from an unreasonable risk. But as I've just explained to you, there was no unreasonable risk. And there is no duty to protect from a risk that doesn't exist. Simple as that. The steps were safe if the employees were safe. But we do have to talk about that employee, Ms. Gilmore. We have to talk about her actions. Now, on this point, it is the defense who has the burden. We had to show you it was more likely than not that she didn't act with ordinary care, and that just means the kind of care an ordinary person would have in that same situation. Folks, I want to put you in that moment. I want you to think about the choices she had. She told you, she's the one who told you that that night was different than all the other nights. She told you it wasn't the railing that was different, the lighting that was different, the stairs that were different, the door. No, she told you that night was different from all the other nights because in her words, it was bitterly cold. Her words. Because in her words, she was hurrying. She's standing at the bottom of those stairs. She is shivering. She's trying to finish that cigarette. She wants to get back inside. She throws that butt into the dumpster. She is so cold. She's getting ready to run up those steps. She's walking up those steps. There's only 4 or 5 of them. She gets to the top, and what does she see? She sees a door blocking her path. Now, when she sees that door, she has a couple of choices. Number 1, she can push that door closed. That walkway is clear, folks. Choice number 2, she can pull that door open. That walkway is clear, folks. Or number 3, she can leave that door right where it is, the most inconvenient place for it to be, and she can try to scoot around it. Now today, Mr. Hayden, that OSHA inspector you heard from, that OSHA inspector, by the way, who didn't want to be here, wasn't paid to be here, was a neutral party. He looked at that step and he told you 95% of that step was good, solid. But what Ms. Gilmore did was she put herself in a position where she was stepping on that 5%. Now that is not something Chimes made her do. It's not something Chimes asked her to do. It's not something she had to do. Folks, all of us have to take responsibility for our actions. Companies like Chimes have to take responsibility for keeping their employees safe, of course. But employees, average people, going about our lives, we've got to take responsibility too. We have to take care. Ms. Gilmore didn't. At the end of this trial, you will get a verdict form. It's going to look like this. You'll be asked, did the negligence of either of these parties cause the injury? Folks, because of the evidence that you've heard, because you heard that those steps were ordinary, you can mark no for Chimes. And because of what you've heard about Ms. Gilmore, because you heard she acted out of the ordinary, she did not act with ordinary care, you can mark yes for Ms. Gilmore. That's it. Plaintiff today has talked about a careless company, but they haven't proved it. What you've seen today is this isn't about a careless company. It's about an employee who was not careful. Those steps were safe if the employees were. I ask that your verdict reflect that. I ask that you find Chimes not liable. Thank you.
All right, any rebuttal?
Yes, Your Honor. May I ask how much time I have left?
You have used 63 minutes and 28 seconds. You have 70 minutes total, so still plenty of time.
No problem at all, Your Honor.
Proceed, counsel.
Members of the jury, the defense just got up here and said that if the steps were safe, they would only be safe if the employees were safe. But I want to talk to you about the truth. The steps should have been safe if their employer made them that way. Ms. Forrester called these steps ordinary. She said they were nothing special. You know, that's not true, especially not to Miss Gilmore. This company wants to blame a veteran employee of 10 years, one of their most loyal employees. Today they said, well, Miss Gilmore should have opened the door further. She should have held on to the wall. How about Chimes make sure that their door is designed properly? How about Chimes make sure that their employees have a hand railing? Think, members of the jury, they could have run to the supply store next door and gotten them a flashlight. They didn't even do the bare minimum. Ms. Forrester wants you to believe that they were reasonable, that they exercised reasonable care. You know that's not true. They had a lack of care. They were unreasonable. And clearly, they have a lack of respect for their employees. I want to talk about something that Ms. Forrester just mentioned. She talked about calling an unbiased witness today. And that was Mr. Hayden. And I want you to remember something that Mr. Hayden said to you today. He said that during his inspections, he calls it like he sees it. And that's it. He doesn't take any photos, doesn't take any notes, any videos. He just trusted the words of a Chime employee and said that was enough. Their lenient inspector, their so-called unbiased witness, based his entire opinion today, the opinion that their case hinges on one conversation with the manager of the defendant's store. Finally, Ms. Forrester talked to you a lot today about numbers. She said, well, there are only 2 occasions out of what are probably thousands. 2 occasions is more than enough for them to be negligent. Even 1 occasion, Miss Gilmore's occasion, that is enough to be negligent. And members of the jury, you heard, they had a prior occasion, a prior incident where this happened, and they did not change a thing. That is unreasonable. Find them liable.
All right, thank you, counsel. Ladies and gentlemen of the jury, it's now time to reach your verdict. And by that, I mean complete your ballots. I understand that once your ballots are all submitted and we've gotten the thumbs up, we'll have just a brief minute to give feedback. So let's wait to do that until I come back on here and give the all clear, okay? Be in recess, awaiting the jury's verdict. Okay, I got the go-ahead to let people give comments as soon as you've sent Robert your ballot. So jurors, if you have sent in your ballots, turn on your camera. And also, where's my lawyer? There are my lawyers. Okay, good. Let's see. We're almost all here.
Well, my video indicates that the host has stopped it and I can't turn it on, but
Oh,
I have
sorry.
sent in my ballot.
Hang tight, Judge Livingston. Let me put you back on. Sorry, you were on a minute ago, and so
Yeah, I don't know how that happened. I didn't turn it on manually. I don't know what happened there. Apologize for that.
Okay, I should. There you go. I think I took someone else off too. If you're having trouble with your camera, another juror, will you unmute yourself? I did that to someone else too. Maybe Marilyn. Let's see.
I think it was me.
Okay. Oh, good. Okay. Are you back on? There we go. 1, 2, 3, 4, 5, 6. We're missing one more. Jordan, you're here. Who am I missing? Oh, Jordan Gilmore. Sorry, you guys. Yeah, I'm revealing my lack of techness right now. You'd think after a year of this, I'd have it down. Which juror am I missing? Let me look. Jordan Mayfield, Jenna. Okay. Can't figure it out. So we're going to get going. Okay, we're going to keep it brief because one of the things we're supposed to do is give you one comment that would help you for the next round. And this is it. You made it all the way to the finals. So great, great job. I just wanted to briefly say, I'm Judge Mitchell. I'm a real life judge in the Eastern District of Texas. And once you pass the bar, man, you're so welcome in my court. You ladies were excellent, excellent. It was just so good. And I was so impressed. And so that's it. That's the ball. I just thought you tried a great case. I was expecting a few more objections, but also a little bit thankful that you kind of had thought it through and worked it out, whatever. So great work. And I'll open it up to the other jurors who want to make brief comments. Okay, Judge Livingston, knock yourself out.
I want to just echo what Judge Mitchell has said, which is that you would certainly be welcome in any court in Texas, including here in Travis County, where I am a judge. You guys did a great job. I was very, very impressed and wish you both well in your legal careers. The only feedback I would offer is that I think on cross-examination rather, that you got to close up those questions. Cross-examination, it's time for closed questions, leading them to yes or no answers, not letting them explain away why they disagree with you. So I would just say, close up your questions on cross-examination. Great job. Good luck.
All right, I'm just going to call on the rest of you. So let's hear from Jordan next.
With regards, I would say you guys did a great job and congratulations on your hard work and your effort. It has definitely paid off. A general comment of something that could be improved upon, I guess, would be when I would want you to tell the story at the beginning, I would rather draw an objection for someone saying we're being argumentative than have a bunch of you will hear. I want to be transported in the argument that you're making in the opening to the situation, not think that you're telling me a story, right? And so tell the story. We won't refer to it as that, but tell it to where people are transported there instead of you'll hear, the evidence will show, to the extent the opposing counsel and the judge will let you. Just tell the story and transport people there so that they feel like they're part of it, not just something that you're doing. I thought that was, as far as something that could be done. As far as great things that were done, I think you did a good job listening. There were a few places I think that we as lawyers, we don't always listen to the judges, unfortunately, and sometimes we don't listen to the witnesses as well as we should. And there was you guys did a great job listening. I remember one of the witnesses threw out and said, I was hurrying, she says, I'm hurrying. The plaintiff says that. And you immediately seized on that and emphasized it. And that's the good place to do that, to work with, listen to what the witness is saying. And Ms. Forster, you did that. Ms. Appler, I liked the way that you tried to incorporate throughout the trial the choices and making choices. Both of you did that. And there's a lot of personal responsibility being a good thing, and people are trying to use that. And you can choose your choices, but you can't choose your consequences type deal. And so I thought you did a good job incorporating that theme throughout. Congratulations to both of you. You did an outstanding job.
All right, Marilyn.
I echo everyone else's congratulations to you for getting this far, and also express that you did an excellent job. I wanted to compliment you each on one thing specifically. Ms. Forster, I thought you did an excellent job in your closing with staying in the moment and maintaining eye contact and making folding in the charge to your story. That can be stilted sometimes to go back and forth from your story to the charge, and I thought you did a really good job of that. And Ms. Appler, I thought that you did a particularly good job of managing a difficult expert witness and not being goaded into answering his questions. That can be challenging when a witness starts to answer you questions. I thought you did a good job of handling that and returning the questioning to the conversation and the questions that you wanted to do in a way that was still professional and poised. So well done, both of you.
All right, Mark.
It's very easy to make short comments because you both did so well. Let me just make 2 comments for both of you. First with Zoe, you do the same thing I do. You use your hands a lot. I would try to pay attention to maybe not using your hands quite as much, and especially when you talk in cadence and you start doing that, just be aware of that. One thing for both of you is jurors don't know what an element is. So it's points or 0.1, 0.2, 0.3. They get, jurors don't know what an element is. Only lawyers do. And for Jenna, what I would try to do, I think, I think you did a good job of this, is try to have an undeniable, develop an undeniable theme. In other words, and this probably shouldn't be it, but to avoid injury, we all know you have to use ordinary care. Something that somebody can disagree with and then stick with it. But you both did a great job, and I enjoyed watching both of you.
Michelle.
Yeah, so I am super happy that there's 2 young women in this final. That made me happy when I got logged on here. Congratulations to both of you. What an accomplishment this is. Ms. Appler, I thought that you were very poised and did a great job on your direct and cross. I thought you did a great job on your objections. One tip that I would have for you for improvement would be to be a little bit more flexible. Your poise almost crossed over into rehearsed at times. And you could have just been a little bit more responsive to what was going on in front of you and less rehearsed. Ms. Forrester, I can't see you on my screen right now. So let me, there you are. Okay. I thought your direct and I thought your opening and closing were spot on. You had the look of a trial lawyer assassin in your eyes. And that's what I was wanting to see from you. I thought you were a little bit nice for a defense lawyer on your cross and direct. So I was looking for you to be a little bit more serious maybe in your direct and cross. So that would be my point for you. But I loved your storytelling and your theme. I love the theme and that you carried the theme from your opening to your closing. Like one of the other jurors said, be careful when you carry that theme through. Make sure it's undeniable, because you saw in Ms. Appler's closing that she kind of tried to turn that around on you a little bit. So just be careful, make sure you think through all your theme. But I thought you did a fabulous job on that closing and carrying that theme through perfectly. So, I mean, to me, this is like a tie. I know that one of you is going to be determined the winner, but seriously, like that is not a loss for either of you, because you are both fantastic.
All right. And Lynn.
great job by both of you. Superb. One of the things that's, I think, really good is that the two of you have different styles. Ms. Appler, you're a little more formal, maybe. Ms. Forster, you're a little more laid back, and that's great. There's no one way to do it, and the fact that each of you went the way that's comfortable with you is a good thing and a lesson for everybody else who's watching. There's not one way to do that. One comment for each of you. Ms. Appler, your rebuttal was superb. The first part of your argument should have mirrored your rebuttal more. I felt like the first part of your argument was a little too much of just a recap. Just let me remind you everything we just heard. And I thought you were a little late to the party with actually arguing. In rebuttal, man, you argued the house down, and that was great. I was hoping for more of that in the first part of your argument, and I felt like it was a little too much of let me remind you what everybody said. Ms. Forster, I thought that in your argument, a missed opportunity was that Ms. Appler really called your client out. She called her a liar. She flat out said that she's not telling the truth. And I don't think your client came across that way. There was this whole big impeachment fight about what does the word inspection mean, and your client had an explanation. And I think you had some ground there to and maybe this echoes the previous comment about being too nice. I thought you had a chance to call out the plaintiff's lawyer on that, but you didn't. And when you didn't, that leaves it ringing in the jurors' ears. This is an undefended claim of lying. And I thought that was a missed opportunity there. Those are minor comments. I thought y'all were both outstanding, and I echo what everyone else said.
Great job, ladies. Okay, I'm going to turn it over to the Dean of Baylor Law School, Brad Tobin, to say a few words. So I'm going to get out of this chair. Hang on.
Thank you, Judge Mitchell. We have had a wonderful 12th Top Gun competition here this year, and I want to echo what each of the judges have said, along with Judge Mitchell, that you have made yourselves proud. We are very proud of our advocacy tradition here at Baylor Law School. We have, of course, a very high profile in trial advocacy. And I can tell each of the contestants here, each of the lawyers, that we would be glad to call you Baylor lawyers. We have been highly impressed. Competition such as this comes off because of the work of just so many people. And of course, as we had last year with the onset of COVID, we all have learned a great deal about technology and how to put on a mock trial competition, a national mock trial competition through technology. That has involved a lot of work by a lot of folks. And I especially want to thank my colleagues, Robert Little, Kathy Sayre, and Stephen Rispoli, who have been at the head of putting on the competition. And also, of course, we have a wonderful IT team here at Baylor Law, Rick Soll, Ricky Levetsky, and Nathaniel Jones, and they have helped immeasurably. The matter of coordinating witnesses is not easy in terms of making sure that they are prepared and that the advocates have an opportunity to wood chip them and the like. And I want to thank especially Jessie Cox. Jessie is a recent graduate of the law school. There are a number of other colleagues of Jessie's in her class who have also helped. I won't name them all, but they are kind of the gang who has made sure that all the witnesses were prepared and in place. I want to thank Judge Mitchell, Judge Nicole Mitchell. I'm sure you're aware that she is a United States Magistrate Judge for the Eastern District of Texas. She has been mightily loyal to the law school in terms of her time over the years. And I'm looking today at the screen, and I see, of course, our Baylor scoring judges, and each of them have introduced themselves. They're all our dear friends of the law school. And I want to thank each of them, along with all of our other presiding and scoring judges who have helped us out over the past few days. The competition is a singular competition, and it is made that in part because we have trial lawyers who are, of course, are our scoring judges, and we have real federal and state judges, such as Judge Mitchell today, who are on the bench presiding at each of our trials. I think that we have had a most successful competition, and I want to extend my personal thanks and the thanks of Baylor Law to everybody who has made it possible. But I want now to especially pull out one of our scoring judges, Jordan Mayfield. Jordan Mayfield is a partner with the firm of Naaman Howell, Smith and Lee. Naaman Howell has a number of offices. And the reason I am pulling out Jordan and extending personal thanks to him and his colleagues is that for the last 12 years, the firm has been the very generous underwriters of the Top Gun competition. We were so pleased when we got this competition underway that Naaman Howell, Smith and Lee agreed that this is a distinctive way to run a mock trial competition. It is going to make waves, and we want to be a part of that. And the partners in the firm have very generously come forward to underwrite the competition. Of course, that includes the $10,000 prize that goes with it. And so, Jordan, I would like, if you will, just a few comments for us, please, on behalf of the firm.
Judge, thank you, Dean Tobin, for this moment. Thank you so much for the kind words. The law school has in part made all of this possible with partnering with great lawyers across this state and great judges across this state. And without their efforts combined and with our efforts in backing them somewhat, it has been a privilege to be behind this, to be part of this. We're grateful to be some small part of this, to watch it happen and to participate in it. So it's a privilege to be part of something like this. And congratulations to everyone that has made this the success it's been for all of these years. We're grateful to be part of it. Thank you.
Thank you, Jordan. Thank you. With that, I'm going to turn this back over to the Honorable Judge Mitchell. I will add this. We've done this for 2 years now, and I don't think that we have had any effect upon the quality of the competition in terms of the advocacy or any of the logistics. And that's been nothing short of kind of a miracle here during the days of COVID-19. And I'm sure that everyone joins me in assuming and hoping and praying a little bit too that next year, during the 4 days of the Top Gun competition, the 13th annual Top Gun competition, that we will be able to mill around the corridors of the law center here, and we will be able to see and enjoy the friendship and camaraderie among all of our judges, and that of course includes both presiding and scoring judges. This is a great Baylor law thing, and every year we try to make it even a little bit better than the prior year. So thank you to all of you for taking the time over these past few days, and especially today on Sunday afternoon, late as it is, to help make this such a wonderful success for Baylor Law and for the entire national mock trial competition community. And with that, Judge Mitchell, I will turn it back to you for an announcement.
Right. Thank you, Dean Tobin. Our reward for presiding over the final round is that I get to announce the winner. I almost don't want to do it because you were both so great. And so just, be so proud of yourselves. Okay. But there has to be a winner. And so let me tell you who it is. The winner of Top Gun 12 is Zoe Appler from the Chicago-Kent College of Law. Well done. Well done, both of you. All right. Thank you, everyone. That concludes Top Gun 12. We'll see you next year. Bye.